regarding their estates, the judge has to come in and agree to it. But the parties, aside from the judge, if they've agreed to the contract and made their settlement a contract, then there's a breach of contract claim.
Fascinating.
Well, you should get comfortable with us because I'm hearing that it could be 30 more minutes before we get started here.
I do wonder what's going on, you know, and certainly not to suggest that, well, anything could be going on.
It could be anything, and it doesn't have to be necessarily something bad. The rules state, so under the rules, all of the senators have to be present on the floor in order for the proceedings to carry on. That's why earlier we saw a moment where they paused for about 30 minutes because Senator Boris Miles needed to step away from the Capitol. All of the senators not only have to be on the floor, but they have to be in the building, in the chamber, to move forward. And, you know, people could need time. They went for a long time.
Late breakfast, whatever. Yeah, whatever the situation
so there's no telling, you know, what, or, you know, perhaps, I like to think maybe we're waiting on a witness. Wouldn't that be a little more exciting?
When you're talking about this many people in a legal setting, it really could be anything. It could be someone's dog needing to go to the vet. You know, it could be anything.
Right. A very much needed doctor's appointment or something of that nature.
Actually, John Gusky, who is helping us get all of this on the air, is asking us if we would like to grab our chairs. I think, why not?
Yes, he's our operations manager. So we're going to look. We're going to look a little bit at, you know, we're watching the senator, and I think we can chat a bit while we're grabbing our chairs here.
We did not anticipate standing in position for
an hour.
Exactly.
We did not. And it's, I don't know if you all know this or not, but I'm a little shorter than Tony and James, and so I'm standing on a box in heels for that amount of time. And it's definitely a little more challenging, I would say, than you might imagine. And so we're just getting in place here as we're continuing to watch. Now, certainly worth noting, though, that there are some senators on the floor. That's Senator Brian Birdwell, I believe, leaning on the railing there, and he headed up the committee that came up with the rules, and so he's playing a vital role in all of this.
And so certainly, again, we've seen Angela Paxton multiple times on the House floor. The prosecution team is clearly there. Rusty Hardin, DeGuerin, you know, and they're waiting. They're waiting just like the rest of us. Actually, clearly, some House members who are part of the House committee. I see House member Jeff Leach, for example.
Yes, these are members of the House Board of Managers. That's Andrew Murr, directly with his back to us.
Who is the chair?
He's the chair of the Board of Managers, and the Board of Managers are the group of House members that are tasked with presenting this case against Ken Paxton in the trial. And of course they decided to hire outside counsel that could be solely dedicated to this. That's not unusual, but the House Board of Managers, similar to, if you know, we all most recently watched the impeachment proceedings with former President Donald Trump, and you saw members of the House who were presenting that case. They're charged with a similar duty, but they made the decision to bring in those, you know, heavy-hitting attorneys, Rusty Hardin and Dick DeGuerin, to prosecute this trial.
Wouldn't you also like to know what the conversations between the jurors are like while they're here waiting? You know, these are still politicians, you know.
Right, and there is a gag order in place, and so they did, and that is something, again, when we talk about the rules, don't forget that it's the senators who made the rules, so they put themselves under a gag order for all of this.
But, you know, they still have the state to run, and they still have a lot of other issues going on outside of this case.
But so, to your point, when you're watching them, I encourage you to watch, particularly anytime the defense is talking. You get a clear shot of a group of lawmakers.
Yes.
Right. It's a lot of Democratic lawmakers in that sort of area of the room. And you can really see the facial expression.
I mean, they're certainly being respectful. They're not guffawing openly. But to your point, you can absolutely tell
some of what they're thinking.
Yeah, if there were thought bubbles coming out, you could get a sense.
Part of what I was explaining when we were talking about, you know, who's the priority on the witness list. as the attorneys, you really are reading the room. You're looking to see what things are going on. If certain groups of people are huddled in this, I would be looking at that and calculating that into what they might be discussing. And you're trying to read the room the whole time to understand what's going on in your jury's mind.
Interesting to note, we saw a shot, and there it is again, of the defense's table, and you can see Dan Cogdell in the first chair, assuming he's going to remain there and kind of take the lead today. I believe that's Anthony Oso sitting next to him.
Mr. Oso certainly had a claim to fame during his cross-examination of one of the whistleblowers. Which actually brings up an interesting point, James, that I want to ask. I mean, again, this is sort of inside the secret sauce here, but how does it, I mean, when you have a big team of lawyers like that on both sides, how does it get decided who questions who and who cross-examines who? How do those decisions get made on a big legal team?
In almost 20 years in the trial law industry, I would bet that these guys, the different teams that we're talking about, they're probably huddling at night. They're probably in it to win it together on both teams. And so if this were a case that I was involved in with a group of lawyers, we would be after the trial together, we would be at dinner together, we would be living, breathing, and eating this trial. So
they're not going back to, the Stephen F. Austin right after they gavel out going to sleep. I mean, clearly.
No, this is probably this is a marathon. When you do a trial, especially a large case, it turns into a marathon. You're constantly digesting information. Like I said, you have to keep up reading the room, reading the jury's faces, because that could change your strategy instantly. If you start talking about a subject where you see that the jury's going sour or getting bored, you might want to change it. And so I would bet that both of these teams are huddling and working late hours and are all having a group conversation. We call it a war room.
Yeah. So how do those decisions get made, though? I mean,
well, the lead attorney is going to make the ultimate call on each side. And it could be that sometimes it just becomes obvious who's got the most information, who has the best personality to match with this particular witness. And then I know some, occasionally you have very successful lawyers like Mark Lanier out of Houston, who I think is maybe the most successful civil lawyer in America. He is very adamant that he handles each witness himself, which is a much different strategy. And you can imagine the mental marathon that takes to prepare for every facet of the case.
Yeah, it sounds like a very type A. I'm curious to know his astrological sign. Because that sounds like a very type A, and I can relate to that, to wanting to do it yourself.
Right, because it makes you nervous when you're the lead attorney to see other people handling parts of your case.
And the rules, and we want to note that the rules of the trial require only one attorney can question a witness. So it's not a situation where they could sign off or have someone else. And they're also not seated next to their co-counsel. So it's not like I can pass you a note, Tony, if I notice something. They're at a podium away from everyone else.
Yeah.
Away from their co-counsel.
On an island.
Really.
Right.
By themselves having to do this. And the rules state whoever starts there's no switching off. That's also why you don't see defense switching off or any trading. Whoever starts with the witness is the only person who can talk to that witness.
James, are you surprised that Rusty Hardin has done, by far more of the talking than Dick DeGuerin? And are you surprised by that? And does that say anything meaningful to you?
No, I'm not surprised by it. I think that this is not their first rodeo in terms of how you handle a trial. I think that, like I said earlier, I think these lawyers are probably pretty excited to be a part of this kind of unusual animal of a trial.
It's history.
Right. And so I think that they are probably, I'm sure that this is a stressful, tireless kind of period in their lives, but I think that as lawyers, they're finding this pretty interesting. And these are lawyers who, like I said, this is not their first time at the rodeo. These are two really well-known lawyers. Rusty Hardin has had his claim to fame for a long time, and Tony Busby as well, handling big cases, out of his office in Houston. These guys have plans and strategies. They're not winging it.
Can I ask you, let's talk a moment about the articles, because again, we have plenty of time here. I want to talk about Article 20, the final article, which is abuse of public trust. And Article 20 specifically, you can see there on your screen, these are the 16 articles that are being heard in this trial.
Just as a quick side note, there were originally 20. 4 are in abatement. Those deal with the security fraud charge, abeyance, excuse me, that's the right word. Those deal with the state security fraud charges that Ken Paxton is facing in a case being heard in Harris County.
And they could be heard are expected to be heard at a later time. So if he is acquitted of these articles, by the state constitution, they can't just not hear those 4. They would have to vote to dismiss those 4. And there certainly could be a motion to do such a thing if he is acquitted. But, we'll cross that bridge, folks, when we get there. But Article 20 is abuse of public trust. And the last really 4 articles are sort of catch-alls, right? They are, if you don't find him guilty of the specific things that we've alleged in the other 16 articles, the last 4 are kind of overall themes. And Article 20, accuses him of bringing the Office of the Attorney General into scandal. Even if you are inclined to acquit on the other charges, how do you not think that this is not a scandal?
It is definitely a big catch-all. It's so broad, it's so vague as to, public trust. That could hit on the financial charges. It could hit on the affair scandal. It's a wide catch-all.
It's going to be interesting to see how this all plays out. Again, I mean, when we first started this process, and I don't want to, count our chickens before they hatch here, but I think we were originally told that this could be a 3-week, a 4-week, even into October process.
Sure.
So it is striking that, we could get to a resolution based on the use of time by this weekend, or certainly early next week.
Well, fair
enough.
And we discussed, optics a few times. You keep in mind this is a majority Republican body, and we were saying, you might not want pictures with bad headlines in the news every day, and so it's probably in their best interest to get this over with and get these headlines off of the news every day, so that they have, that their reputations aren't damaged.
And certainly before we have a third special session that was expected to start in October, dealing with school finance and school choice, and ahead of the November election. So we talked so much about, and they spent so much time fighting about property tax relief. This was something that was promised by, I think, the heads of all chambers and Governor Greg Abbott himself. And after, a failed first special session, they were able to pass legislation in the second special session, but it's contingent on voters approving it. And so I think they're going to have a lot of work to do in terms of campaigning to get people to vote for that legislation in November. And so, which early voting starts next month. And so they've got things to do other than, have an impeachment trial.
And we've talked about the difference between the prosecutor strategy and the defense strategy, and that the defense is, looking for ways to cast doubt. And that's something that might be kind of parallel to the Republicans and Democrats in this trial, because this is also a great opportunity for the Democrats to show, look at the majority Republican Senate and look at their bad headlines every day. So I would think that the Democrats in Texas would use this to their advantage.
So, I mean, just in turn, I certainly ask people this every time I have a chance to talk to them. But, do you, as you assess this situation, do you believe that the defense has done enough to cast those seeds of doubt?
Well, they're doing their best, aren't they? But it's going to be hard, especially like you said with, number 20 with, a catch-all. How how's it possible to say that there's not a scandal, or how that you haven't broken, the trust of the state?
I think the other thing that I wanted to ask you about that is, in Tony saying, have they sown seeds of doubt or landed any punches? And this is actually, you can see here, this is what Article 20, yeah. So this is the catch-all one that we've been talking about. And it alleges that Paxton, used, misused, or failed to use his power for the lawful operation of government, that he obstructed fair and impartial administration of justice, talking specifically, I think, to what happened with Nate Paul and the investigation, and then that he brought the office into scandal.
So, James, I actually want to ask you about that. So, as charges go, I mean, obviously this one has multiple prongs. It has to be yes to every prong. Well, I guess I should ask you, does it have to be yes to every prong for a yes on the entire article, or can they say, oh no, he did bring the office into scandal?
When you look at statutes or laws or jury charges like this, a lot of times you're looking at the second to last prong to look for which word they use. Are they going to use and, or will they use or?
Right.
And so here we're on this screen, I'm not sure if we have and or up here, but very often when I'm looking
Ashley's calling.
So I'm calling them up, and in a moment of transparency, these are the notes. These are my personal notes on
right.
that you're seeing on the screen there about what the articles are. And so basically, this is my way of summarizing what each of the articles says. So you said, is there an and or? And so I'll just read it for you because, again, we've got time here. So Article 20, and it is called abuse of public trust, alleges that while holding office as Attorney General, Warren Kenneth Paxton used, misused, or failed to use his official powers in a manner calculated to subvert the lawful operation of the government of the state of Texas and obstruct the fair and impartial administration of justice, thereby bringing the office of Attorney General into scandal and disrepute to the prejudice of public confidence in the government of this state, as shown by the acts described in one or more articles.
Right. And so that means that all three of these prongs need to be met in order for the article to be found against him. And something interesting,
But can I just say that made me pat myself on my back? That means I did a good job with the summary. Thank you for that, James.
Yes. The kind of hinge here is the used, misused, or failed. And that in and of itself is a catch-all, because that means either you did something wrong, you've failed to do something that you could have done. That's a big catch-all. That's something that we use a lot. We say negligent acts and or omissions. That means either you did something wrong or you missed the chance to do something right. And so that's a big catch-all.
And so many of those last four are just like that, whether we're talking about 19, talking about whether he is unfit for office, or 18 that alleges that, a declaration of duty, or even 17 that he misappropriated public resources. I mean, so many of them have those kind of overarching
more sweeping themes.
Yes, yeah. That basically, what you did overall was just sort of wrong. And so I think it's kind of hard to reconcile, even if you want to argue that, okay, well, the hiring of Brandon Kammick, which is subject of one of these, is fine. And the whistleblower, you terminating them, well, we've given some, at least for a few of them, they've given reason as to why, they were fired. The reason that was not the case, we'll want to know, with David Maxwell. He was not given a reason, he said, as to why he was fired. But, when it comes to the whistleblowers, even if you say, okay, I can see a reason for all of those other ones, when you have those big catch-alls at the end, it's sort of hard to tell.
James, I want to ask you about the unique nature of sort of the quote-unquote punishment in this case. So in other words, yes, there are federal sentencing guidelines. Certainly in state district court, we see a range of punishment. Same thing with both civil and criminal. But the penalty for Ken Paxton is baked in insofar as if he is convicted, even on one article, he's out of office.
Right. And so we've talked about some of the rules of this trial and the differences of this trial to a federal trial or a state trial for that matter. And that's probably one of the reasons that the rules are a little more lax in this trial, is that the consequences are not quite as bad. You're not talking about someone on a murder charge who could be sentenced to death or life in prison. You're talking about one person being pushed out of a public office.
Though politically, it is something of a death penalty, I think, in some way, potentially, right? Because there's it's a two-pronged, right?
Right. So I want to note that if you are convicted, you are removed from office automatically. But after you are convicted, if you are convicted, the body then votes on whether or not you can ever run for office again.
Correct.
And that, I think, is the big punishment, if you will, that would happen for Paxton. Because if he is convicted and removed from office,
he can run again.
He could run again. Governor Greg Abbott would appoint an attorney general, and then he would call a special election. Those things would presumably happen in 2024 to allow, just frankly, the timeline. We're already in September here, so when you think about how it will play out. And then Paxton could run again, and he could run again, and I do frankly see a world where Paxton could run again, and this is going to be not only an off year, but an off-season election. It's going to be an election with one thing on the ballot, Attorney General of Texas, which means it will be hard to get voter turnout, particularly in a state where we have a voter turnout that's already less than 50%. And so you then have the base voting.
Well,
right?
we're also seeing a trend of defiance amongst voters, defiance and retaliation for charges, and investigations, that the voters become more influenced to go for that person, which is kind of a new development in my life of watching politics, that you've got people facing criminal charges and there's a surge in their popularity. And I think you have to think about, though, who's voting. When you look at those and when you look at the number of who's voting, and really, look, it is dismal. Our voter turnout numbers. It just is what it is. People don't vote. The people who go vote are the people who are fired up to cast a ballot, those who are tuned in, and you have the minority of Texans deciding for the majority of the state, and it's.
But those very passionate primary voters.
Yes, and I think it's I think it's troubling, because I would love to see a world where we have 80-90% voter turnout.
It cannot be reflective of the population.
But I think if we enter a world where we have a February 2024 election, it's not tied to the primary, because I can't see him calling it for March, calling it for the same as the primary. That would just be, then again, I'm in my mind, I'm thinking about the political strategy of all of that. It could work out, how it works out. But we could see that happen. And so I think, I don't know that it serves the Senate to convict and remove from office and then allow him to run for office again.
So, yes, very, very fair point. And one that will definitely play out in the next few days. Actually, if we just want to take a pause here as we near the 10 o'clock hour, just to bring people up to speed, the sixth day of the historic trial, impeachment trial of Kenneth Paxton, the first statewide elected official to face ouster from office in more than a century, has yet to start this morning. We are looking at what began as a 30-minute, 15, then 30, and now, we're now approaching a 1 hour delay. No reason has necessarily been given, but as we've been saying,
it feels like a normal day in court.
Is this what? I'm glad that you
say that. Say more about that, please.
But it really could be for any reason.
Yeah. Mundane or not.
Yeah, and we're only at 1 hour delayed. I mean, I am not too phased at this point.
Well, please note that us, the TV people who deal on very strict deadlines and very, the timeliness is important in our world.
Oh, this is a deadline business. I mean, all of law practices deadline, deadline, deadline. It's kind of that phrase, hurry up and wait, when you get to the courtroom. You have some judges who are very punctual and will set your appearance times down to the minute, and you are on
Better,
that minute.
yeah.
And then sometimes in a court proceeding, there will be 30 cases on the docket that morning, and you're just sitting there waiting until you're called amongst the 30.
As we're joking about punctuality, I think it is certainly worth noting, while we've seen senators come and go from the floor, there's only one senator seated in his seat, ready to go. And of course, it's Lieutenant Colonel retired Brian Birdwell from the U.S. Army, who was here punctually on time, ready to go, and is seated now, waiting.
And I tell you, I don't know that I would be in my chair any longer than I had to be,
I hear they're comfy.
Okay.
I hear the chairs are a little comfy.
10 hours is still a long time to be
well,
comfy or not. I mean, I'd rather it be more comfortable.
Sure.
Yeah, absolutely.
It's definitely a whole lot better than the wooden, pews that we use in the district court.
There you go. There you go.
Absolutely, I am sure. And so we're expecting to get started any moment now. Let's rewind and talk a little bit about what we've heard thus far. Rewind, you're hearing me say that a lot, Tony. Look, I see Patsy Spall going to her post, and that's the Secretary of the Senate. It's giving me some hope that they're going to get started here soon. Week 1 moved at a much slower pace than we have moved on this first day of week 2. So week 1, throughout 4 days, over the course of 4 days, we heard from 4 witnesses. And those were Jeff Mateer, who was the former first assistant, so basically Paxton's right-hand man. We heard from Ryan Bangert, the former deputy first assistant of the Attorney General. You heard from Ryan Vassar, who was the deputy attorney general for legal counsel. And then finally, David Maxwell, who was the former director of law enforcement. All 4 of these men are whistleblowers, so they are 4 of the 8, but only 2 of the 4, Ryan Vassar and David Maxwell, are part of that whistleblower settlement that would have the lawsuit and settlement against the Attorney General's office that, again, triggered this entire impeachment proceeding. And again, we went very slow, very methodic on each one, on Mateer.
Mateer was on the stand for like 2 days.
Over 2 days. So the only one of these witnesses that was finished in 1 day was David Maxwell. So the first day started with Mateer. Day 2, we had Mateer and Bangert. Day 3, Bangert and Vassar. Day 4, Vassar and Maxwell. And Maxwell gave such powerful testimony. You knew that it was intentional when we talk about the strategy for them to end on Friday with Maxwell, because you had spent 4 days listening to attorney, and then here we go with a straight shooting Hall of Fame Texas Ranger who told you like it was. I see you nodding. Tell us a little bit about your thoughts on that strategy for this lineup during week 1.
Well, in reading the room and looking at a jury, you want to make sure that you're not boring them. And in a case like this where you're talking about, lawyer after lawyer talking about the same kind of subject, you might need that exciting witness to bring the attention back. I think that was a good strategy also because, as you get to the end of the week, you want to kind of leave off on Friday with something memorable that is kind of a, part of your, you want your jurors to go home and think about it over the weekend.
To use Tony Busby's phrase, let's let that sink in.
Right.
Has been one of a phrase that he has used several times. Then as we go to the week 2 witnesses, of course, we are only
1 day in.
One day in, one day and 1 hour in. But we have heard from Mark Penley, who was also part of Ken Paxton's executive team. Actually, he really talked about the first time that he had coffee with Ken Paxton to discuss him joining the Attorney General's office. It was a coffee meeting in Dallas, and he talked about how at the conclusion of that meeting that he and Ken Paxton got on the phone with Nate Paul so that Nate Paul could explain what Penley and others have described as this vast conspiracy theory, this crazy conspiracy theory about corruption within federal law enforcement, including the FBI. Then, Ashley, we heard from Missy Carey, who was the first female chief of staff. She was also the first person to rise to that level within the agency after starting in the agency as a line attorney. And as we have discussed, her testimony appeared reluctant in many ways. We also, of note, she confirmed that she also has provided testimony in the ongoing federal investigation into Kim Paxton's alleged conduct.
And we want to note, she's not, now Mark Penley is one of the whistleblowers, and he was fired. Missy Carey is not.
And is a plaintiff.
In the lawsuit, Penley is. Missy Carey is not a whistleblower. So as all of this was sort of happening, she made the decision to retire. And she'd already set those wheels in motion. And she was, in fact, when the whistleblowers went to the FBI, she was retired. And she said she was 3 hours away. At that point, she was 1 foot out the door. So she did not take part. She says she was invited to take part of it, but she made the decision not to.
And then with regard to the other witnesses, we have heard Greg Cox, who was a director in the Travis County District Attorney's Office, who testified about the hiring of Brandon Kamek, or the lack of hiring from their agency, according to he and Margaret Moore, Brandon Kamek, the special prosecutor in this case.
And the investigation that they started to do, that they had a long list. He was over the Public Integrity Unit, which is the unit, guys, I need my coffee. That unit is in charge of investigating
allegations of wrongdoing, yes,
from elected officials. And so he said that he had really a laundry list. He named a list. He named all of those allegations that he was both possible, he called them possible violations that he was looking into, that, ultimately he said that they stopped at the request of a U.S. attorney who was also looking into the Nate Paul
James, one thing that does not seem to be in dispute that I want to ask you about, and that is this notion, this I think fact, according to the testimony by multiple people, and that is this special prosecutor is hired from Houston. His name is Brandon Kamek, Kamek. This idea of him serving subpoenas accompanied by Nate Paul's attorney, Michael Wynn from Houston. What do you think about that?
It's very unusual. And let me just
and potentially illegal, according to the House prosecutors.
Let me back this up and tell you a little bit about, open records requests is kind of where some of this started. Open records requests are always handled by the Attorney General's office. Anybody can file an open records request. It could be a news agency, it could be an attorney, it could be a concerned parent about their school. You can ask the government, the state of Texas, for records about anything under the sun, and they have to produce information to you under the Open Records Act. The thing is, if there's information that they don't want to produce to you, if it's confidential, if it's a matter of security, if it's an ongoing investigation, that agency or city has to go to the Attorney General's office for an opinion, and the Attorney General will weigh in and say whether or not they're going to withhold records or not. I read that there's about 50,000 open records requests per year that the Attorney General's office reviews. We do a lot of them, even from my office. We send a lot of open records requests in. So they're very everyday, normal thing to see. For the actual Attorney General to get involved in that is so unusual.
Great news, folks.
We're at 10:07 a.m. An hour and 7 minutes later, Lieutenant Governor Dan Patrick is walking onto the dais, accompanied by Judge Lana Myers and his legal team, which means we are getting ready to start. We would expect the jurors, the senators, to start walking in any moment now. For this delay, interested to see if he's going to tell us why we're delayed this morning. Let's listen.
Bring in the jury.
Nope, doesn't look like we're going to get an answer, at least right now. So That's Austin Osborne, who is the bailiff. He is actually the head, if you will, of security of the Senate, and so he is going in to bring the jury in now, all marching in together.
Yeah. And it could be that he didn't give a reason for the delay because, like we've said, this is a jury comprised of a lot of attorneys and people used to courts and trial practices, and they're probably not fazed about the delay too much.
The Texas Senate starting an hour late. You can see they're smiling and seem quite jovial. So
atmosphere,
I don't think it's anything of concern for us. There we go. State Senator Angela Paxton, the wife of Kenneth Paxton, looking up at the gallery, waving, smiling to folks in the gallery. Again, we talk about political strategy.
I mean, it seems, I don't know her, so I certainly can't make a determination of if that's sincere or political strategy, but it does communicate something, right, James?
I think so, because people don't like to be in trials.
Will our prayer leader come up to pray?
And so if you know anything about the state Senate, the Senate always begins with prayer, as does the House anytime they're meeting. And so they're going to start now. Let's listen in.
Heavenly Father, we come before you today with humble hearts, seeking your guidance and your wisdom as we embark on our work. We pray for strength and clarity of mind and ask that you grant us the gift of strength and courage. Your word assures us in Isaiah 41:10, "Fear not, for I am with you. Be not dismayed, for I am your God. I will strengthen you. I will help you. I will uphold you with my righteous right hand." Lord, we hold on to this promise, knowing that you are our source of unwavering courage. Strengthen our resolve to trust in your plan, even when the path before us seems uncertain. We also pray that we may be instruments of your righteousness, discerning right from wrong, and upholding the principles of fairness and equality. Lord, we thank you for being our ever-present help in times of need, and for the wisdom and the grace that you provide. May we walk boldly in your light, knowing that you, by our side, we can conquer all obstacles. We offer this prayer in Jesus' name. Amen.
Thank you, Senator. You may be seated.
Yes, I was going to ask.
And so we are getting ready to see the big question I think we're all waiting to see right now is who is going to be the first witness called today.
To the public and to the media and to the members, we are beginning late this morning. The court's always ready at 9 a.m., but both the House and the defense had issues they needed to bring forth to the court, and so we have walked through some of those issues. Can I have both sides come to the bench, please?
So there you have it. We finally got a reason for that 67-minute delay that we had this morning. The attorneys needing to work out some issues, which they've certainly did not kick this off on a positive note. We want to note when the trial first started.
Definitely not. And at the same time, though, James Wood joining us, Austin attorney. I mean, James, these types of things come up, right? I mean, consistently during a trial. Can you talk about some of the nature of things that can happen?
Sure. In any trial, you're talking about, motions being made, issues being had. They're going to want to talk about what evidence they're allowed to talk about to the jury and what evidence they're not allowed to talk about in front of the jury. And so these are typical issues. You have a bench conference like this, all the time in a trial, and one fought so hard as this, and with so much political motivation, and consideration behind it.
So much at stake.
This is not surprising to me at all.
And I say they started off with some contention. The prosecution and the defense were supposed to agree to what evidence was going to be submitted prior to the start of the trial. That's something that Lieutenant Governor Dan Patrick said on the first day, and Rusty Hart had made it very clear that they were not going to object to any of the evidence that the defense wished to put in, but the defense did not grant them that same, courtesy that they said they were going to look at it. They said they were going to do it, but they never heard back from them. And he was quite frank with that. And so then there's been little, objections here and there and discussion about what evidence would be submitted and not submitted. There's also conversation, and would love for you to explain for our viewers at home, about direct and redirect, and basically them saying that you could not present new evidence during a redirect. But there was a little bit of confusion about that, because then they kind of agreed, well, if the defense presents something new on redirect, then in my redirect as the prosecution, I can address it. Talk to us about that.
A redirect, in other words, is more of a clarification of things that have already come up. It's not a second chance into this. It's a clarification of what was covered in cross. On the notion of agreeing to evidence, I mean, without giving an opinion as to whose evidence is better, I think that's up to the jury. Let's just look at the quantity of evidence and what there is. It's just the facts that the prosecution has so much more quantity of evidence, and the defense, their job is really just to say no and cast a doubt as to that evidence. And so it makes sense to me. This process in a regular court, we call it a motion in limine. When you're talking about what's allowed to be talked about and what needs to stay out of the jurors' ears, that's called motioning in limine. And so you're looking at what can be discussed and what can't be. But a defense job in this is just to say no and cast doubt.
All right. So again, we're all on sort of pins and needles here, waiting to see who the prosecution is going to call next in there.
Right. And we talked about Mindy Montfort earlier.
Yeah,
and it
seems like a good candidate, right?
Oh. Here we go.
Kamek?
It's Brandon
Kamek. Okay.
We are starting with a bang on this day 6. Brandon Kamek is certainly the center of some of the articles, because Ken Paxton is accused of hiring Brandon Kamek, a young attorney, without, frankly, without any actually prosecutorial
5 years out of law school, and is going to investigate the federal government.
Right, and started serving subpoenas. So I think we are all interested to hear what he has to say as he is taking his oath and his promise to tell the whole truth and nothing but the truth. Let's listen in.
Having been a 5-year attorney at one time, it probably felt like a lot to take on.
Yeah.
And before you begin, I've always been asked by both sides, I meant to do this earlier, the time clock. Presentation of the evidence, the House, 9 hours, 19 minutes and 12 seconds left. 9, 19 and 12 seconds. Respondent, 12 hours, 14 minutes and 15 seconds left. 12 hours, 14 minutes and 15 seconds. You may begin.
Good morning. Fine. Is your microphone on, please, sir?
Can you hear me? Is that better?
That's better.
Okay, good morning.
All right, Mr. Kamek, obviously, but state your name for the record, please.
My name is Brandon Raymond Kamek.
And Mr. Kamek, how old are you?
37, sir.
And as we've gone through this, you're doing really well about leaning forward. The microphone, I think that microphone and this one requires to be pretty close. I sometimes may call it to your attention, but if you can just sort of try to keep it in mind, that would be good.
Okay.
Now, what's your profession?
I'm a lawyer.
And can you take about a minute and a half, if you don't mind, and sort of give us a little bit of your background and experience, whatever got you to where you are now?
Sure. It all started I went to school at University of Houston for my undergrad. I went to University of Houston Law School as well. Graduated in 2015. During my time at U of H, I interned for the Public Defender's Office in Harris County. I clerked for the 208th District Court in Harris County for Judge Denise Collins. When I graduated, I went out. My dad, Sam Kamek, is also a criminal defense lawyer. I got out and started working for him. I worked for him for about 3 years, and then went off on my own, and I've been on my own. I guess for the last 5 years now. And then about last year or so, I partnered with Ben Friedman, who's my business partner. We have a criminal and a personal injury docket. I think I've personally, at this point in my career, handled close to 600 cases, probably tried 15 to 20 cases, somewhere in there. Handled appeals up at the Court of Appeals in Houston. I've argued at the Court of Criminal Appeals, and that's what I do. That's how I got here.
All right, fine. When you say you graduated from law school 2015, and I believe you said you're 37?
That's correct.
So did you do something in between undergraduate and law school?
No, I didn't, sir. I just went straight into law school.
Okay. So when you graduated from law school 2015, you were what age?
It's 29.
All right. So I'm still trying to fit back. Ordinarily, you'd be 25 if you went straight for college. Did you do something before college or so?
I went to school for 2 years, and then I started working for my grandfather, Sam Kamak Sr., Sam Kamak II, for his business. And then I just took a few years off, just focused on working and making a living, and then decided to go back to school at my dad's advice.
Gotcha. So your grandfather was in what kind of business?
He was a business owner. He did a variety of things throughout his life, but he was a commercial real estate developer and also owned a mortgage business. And so I worked with him over there.
How long did you work for him?
I was there, I'd say 2 to 3 years or so, and then decided to go back to school.
All right, now, as you're aware, the time frame we generally hear about are events in the year 2020. At that time, how long had you been a lawyer?
About 5 years.
Okay. And by the way, I think congratulations are due. Did you just recently get married?
I got married to my beautiful wife, Terry, on September 2nd, So
you have been married now how long?
A week and a half. We didn't get to do a honeymoon.
And is your wedding one thing that sort of set the time frame as to when you might be available as a witness in this case?
Yes, sir. That's why we didn't. I'm here, so we didn't get the honeymoon. We'll do that next year.
All right. Now, at the time that, let's say in the period of time of August of 2020, you'd been a lawyer about 5 years, is that right?
Yes, sir. That's correct.
Had you had any federal practice at that time?
I believe at that time I was licensed in the Southern District, but my practice was primarily in the county and district court, state court cases.
And was it at that time exclusively criminal?
Yes, sir. Exclusively criminal.
And you've added sort of a personal injury component to it since 2020?
That's correct.
All right. And in your criminal practice, had you ever been a prosecutor?
No, sir.
So had your experience been literally exclusively, as you have described, doing criminal defense work?
That's correct.
So if you hadn't been a prosecutor, is it fair to assume that maybe you had never dealt with issuing grand jury subpoenas or dealing with a grand jury in the role of a prosecutor?
Or issued grand jury subpoenas as a defense lawyer.
Okay. Now, you probably had prepared packets representing people for a grand jury, urging them that whatever your client's position was, correct?
Yes, sir. We've presented grand jury packets to the grand jury through the DA's office when we turn those over.
All right. Now, at the time, can you tell us when you first got involved in this case now? When did you first hear from someone, and whom was it?
It would actually be on my birthday of 2020, August 22nd. That's when I first knew about Mr. Paxton reaching out to me. I got a call from an unknown number on that day. I think I was out to lunch with some friends or something. And then later that evening, I got a call from a gentleman named Michael Wynn, who I knew through the Rotary Club, and said that Mr. Paxton had reached out to me.
Excuse me, I didn't mean to interrupt on you. Mr. Wynn, was Mr. Wynn already a friend of yours or an acquaintance? Would you describe, as of August of 2020, how would you describe your relationship with Mr. Wynn?
Just an acquaintance. I knew Michael. I've been heavily involved in the Rotary Club, which is a charitable organization. We have a downtown Rotary Club of Houston. I've been involved with charities for like the last 6 years, I think, and he became a member of that year. And then I had worked with Michael. He was a chair of the Houston Bar Association. I was a member, and he had reached out to me, I think, earlier this summer to do a panel on how the courts would conduct business during COVID-19. And so I reached out to Judge Rosenthal, Judge Susan Brown, Kelly Johnson, Judge Jordan, Herb Ritchie, and there was a gentleman from Baker Botts, but we basically did a Zoom panel on how we would conduct business. So that was my only interaction with Mr. Nguyen.
All right. Did you become, as you got to know him, did you become familiar with the fact that he was a former federal prosecutor?
Yes, sir, I did.
And what was your knowledge as to his background at the time of this call that you just described that you got from him?
Well, at that time, I didn't really know much about his background other than just, it was more just like when I would see him in passing, or at a Rotary meeting, how you doing? I didn't really, it wasn't like a friendship or anything like that. I just knew him from those two settings.
Now, you mentioned your father a while ago was and is a lawyer, but at the time that Mr. Nguyen and ultimately the Attorney General reached out to you, were you in a solo practice or were you with your father?
I was in a solo practice at the time.
And did you have a secretary or anybody or paralegal or anybody helping you?
I had a legal assistant, and I think at that time I maybe had one other lawyer working for me, and my older brother was in law school as well, and I sponsored his bar card as a temporary bar card or something like that.
All right, so that if you got involved into a case that involved potentially a great number of documents, witnesses, et cetera, the support you would have had would have been what?
I don't understand the question.
The support groups, I mean, what kind of legal support would you have had in order to be able to conduct an investigation or something?
Well, the documents that I received just personally to my email.
Okay. Now, tell me the nature of your call from Mr. Nguyen.
Mr. Nguyen had reached out to me and told me that Mr. Paxton was trying to get in touch with me. Didn't really say anything more than that. The call that I had gotten on my birthday from Mr. Paxton was from an unknown number, so there was really no way to call back. And then it wasn't until the next day that I spoke with him.
And so as a date for the jury to have, the date that you spoke with Mr. Paxton was what date?
That would have been August 23rd of 2020.
And by the way, up there, did you have with you, not that you did you have the invoice you ultimately sent to the Attorney General's office?
No, sir.
Did you bring it to the stand with you?
No, sir. I don't have anything in front of me.
Do you want or need that as a point of reference for dates? Or if you don't, that's fine. Or would you like to have available a copy in order to periodically check things? It's totally up to you.
I'll take it, sure.
Pardon me?
I'll take it, yes,
okay.
Sir.
Mr. Hardin, this is his bill.
This is Exhibit 227, which I move to introduce if it is not in evidence.
No objection.
Admit Exhibit 227 into evidence.
Now, I'm not going to really regularly be talking to you about this necessarily, but I'm offering it to you as periodically if it helps you plug in some dates.
Okay.
Have you, in our conversations previously, have you sometimes referred to this to make sure you were comfortable with certain dates?
Yes, sir. With respect to the dates, this would be helpful for me to remember.
Right. Now, let's go to the first. By the way, did you learn as you went along, thank you, Stella, that Mr. Nguyen was the one who recommended you to the Attorney General?
Yes, sir. Mr. Paxton told me that when I met him.
All right. So now let's go to that conversation, your first conversation with the then Attorney General, Mr. Paxton. Did you return his call or did he call you?
I believe I returned his call. I returned his call the next day and we spoke, and he asked me to, he said he would, he had gotten my name from Michael Nguyen. I think the words were, my name was dropped in the hat by Michael Nguyen, and I'm looking to hire someone to work on a criminal investigation, and we scheduled a time for me to come out to Austin here to his office.
So, 5-year lawyer, solo practice, what was your reaction?
I mean, I was excited because it was the Attorney General's office, and so I was excited for the opportunity to go out and meet him.
All right. And did you do so?
I did.
And when did you do it?
I believe that was August 26th. Our meeting was on August 26th.
All right. And in the August 26th meeting, hold on just a second. All right, so tell me about that. Did you drive up to Austin or up to here?
Yes, sir. I drove out to Austin.
Did you go anywhere else first?
No, sir. Just came straight to meet.
Straight to the Attorney General's office?
That's correct.
All right, describe for us that meeting.
So I went in, I signed in the front desk, and then I went up to the floor where his office is, and I think I waited around maybe 15 or 20 minutes, and then Mr. Paxton came to the floor, and we went into his office, and then...
All right. Who was in the initial meeting between you and Mr. Paxton?
It was just me and Mr. Paxton in his office.
Do you recall about what time of day you talked to him?
I think that would have been... I don't recall the exact time, but maybe around lunchtime, somewhere in there.
Okay. Now, what did Mr. Paxton say?
So before I got there, he had actually reached out to me through text messages and said, "Can you bring a resume with you?" And I was like, well, I haven't prepared a resume in a long time, but I went ahead and prepared one, and I brought my resume in, and then it was kind of like, our conversation that we're having now. Where are you from? What do you do? Your background. I gave him my resume and just kind of pleasantries. And then he said that he was looking to hire a special prosecutor to investigate a criminal case where potentially there were potential violations of the Texas Penal Code.
And you mentioned special prosecutor. Was that his word?
Yes, sir.
And so, of course, you hadn't been hired at that time, but later when you were, whenever you represented yourself as a special prosecutor, where did that term come from?
Mr. Paxton.
All right. And did he tell you what the role of this special prosecutor he was interviewing you for would be?
No, sir. Not really.
Initially, when he talked about this job, what did you think it was going to entail?
My understanding, this was just an assumption. I was like, well, if I'm going to be hired as a special prosecutor, I would potentially be presenting a case to a jury maybe at some point, or presenting the case to be charged. That was my initial impression.
And he didn't tell you otherwise at that time?
That was, like I said, sir, that was just my assumption of what the job would entail.
All right. And then how long would you estimate you talked to him in this initial meeting in his office?
Roughly 15 or 20 minutes.
Did he express anything, any views about his own staff or why he was hiring somebody from outside?
Yes, sir. He said that he was interviewing multiple people, considering multiple people for the position, and that he couldn't get his own staff would not work on what he wanted them to work on.
All right. They said they would not work on it?
That's correct. And he mentioned that, he just wanted to find out the truth and about what happened.
Okay. Do you recall anything else from the conversation in that initial meeting?
No, sir. I mean,
And then what happened after you had this original meeting with him in his office by himself?
He said, I want to introduce you to someone. I obviously knew who Mr. Paxton was. And he said, I want to introduce you to this first assistant, Jeff Mateer, whose office was down the hall. So he walked me over there, and I met with Mr. Mateer in his office, just Mr. Mateer and I. And
now how would you characterize or describe Mr. Mateer's reaction when he came in and introduced you?
It was the same type of conversation, pleasantries, how are you? I gave him my resume. I told him, the conversation kind of didn't really get off the ground much. Just like, I'm here for the special prosecutor, interviewed for the special prosecutor position. And his attitude was kind of like disengaged about it. Knew about it, but didn't really seem interested in it. I'd say, kind of just like it was Mr. Paxton's own deal that he was focused on. It wasn't obviously wasn't an area of focus or concern for Mr. Mateer.
Did it strike you in any way as if his attitude was, so this is Mr. Paxton's deal, he's not that interested in it?
Sustained.
Thank you.
Then you tell me how it did strike you.
I'm sorry, sir.
How did it strike you as to Mr. Mateer's involvement in it?
Just he was very disengaged did not seem interested in it at all. Seemed like it was just kind of a side deal that Mr. Paxton was working on. It was his own focus. Mr. Mateer was not focused on it at all.
How long would you think you were in Mr. Mateer's office?
Say roughly 20 minutes.
Had Mr. Paxton left you there by yourself with Mr. Mateer?
Yes, sir.
And then what happened after you finished meeting Mr. Mateer?
I went back over to Mr. Paxton's office, and he was in there, just him and I. And I said goodbye, thank you for the opportunity, thanks for calling me out. And he said, okay, we might be in touch with you. So I drove back to Houston.
All right. So how was it left when this was all over in that first meeting?
I'm sorry, how was it left?
How was it left? What was supposed to happen next?
Well, I really didn't know. I mean, I looked at it like, okay, I just interviewed with Mr. Paxton and the first assistant, and so if they want to talk to me, they know how to get in touch with me.
All right. So you left, obviously. What's the next thing that happened in connection with this case?
I got a text message from a gentleman named Mr. Vassar a couple days later, asking me to set up a time to meet with him.
Do you recall the date or so that you got the text message?
That would have been August 26th or 7th, I believe. It was August 28th, maybe. 27th, 28th.
I'm looking down at Exhibit 227, and I notice it looks like the first time you charged was 9/3. So did you choose not to build the state for that first meeting or two when you went up there?
That's correct. And also I'd like to say that's a typo, that 9/3/20 date. The date that I actually went out there for the meeting was 9/4/20. So I made a typo there.
Okay, all right. Now, at the end, once you got back, you got the text from Mr. Vassar, what happened next?
So we scheduled a time to speak on the phone that day. That's what the text message was about. And we got on a call together.
All right. And did you ultimately send a draft or receive a contract or proposed contract from Mr. Vassar?
Yes, sir. He asked me for my email address on that phone call. And, I told him, this is about the special prosecutor position. And he agreed. And then he said, well, I need your email address. I'm going to be working on a contract for you.
Okay. Did you receive that contract?
So, yes, sir, I did.
When?
Well, I got the contract on 9/3, September 3rd, but I didn't, it must have got lost. I get hundreds of emails that just got lost in the shuffle somewhere. So Mr. Paxton actually reached out to me on 9/3 and said, did you get the contract by text message? And I said no, because I was supposed to go out there on 9/4 to meet with the complainant, Mr. Paul, and also Mr. Paxton. So short answer is I got the contract, I just didn't see it that day. It got lost in the shuffle somewhere.
All right, so tell me about how this appointment or arrangement set up for 9/4. Whose idea was that? So I got a call from Mr. Paxton, and it was kind of like, hey, we want you to do this job. And excuse me if I interrupt. Did you consider that the notice to you that you've now been hired?
Yes, because he said I would be getting a contract. You got the job, and then he asked me, what's the hourly rate that you would charge to do this? And I said, well, I'll do it, for $300 an hour. And he said, I think we can get that for you. And, now
I'm just guessing. You correct me if I'm wrong. In your criminal practice, customary to your billing, were you charging people hourly ordinarily, or was it usually some type of flat fee arrangement?
On criminal cases, flat fee. On personal injury cases, contingency fee.
So did you have experience in charging that fee of $300 an hour, or were you just sort of guessing?
It wasn't guessing. I just was trying to consider, what was going to need to be done in the case.
Okay.
And so I landed on 300. I thought that was fair.
All right. Now, when you had that, how long did that phone call that you're describing, was that your second call with Mr. Paxton?
Yes, sir.
All right. And then how long did that call last?
I don't recall. It wasn't very long. A few minutes, maybe.
You gave him your hourly rate, and then was there an appointment made for when?
So there was an appointment made for 9/4, September 4th, 2020.
Who picked that date?
We agreed to that date because I was going to meet the complainant, or Mr. Paul, that morning. And so after, I'm in Houston, so I'm driving back and forth. I try to meet them both the same day. So
when did you receive Mr. Paul's name as the person that you were going to be, that you say complainant? In other words, describe what you meant by that when you said he was a complainant.
Well, he was the one who had made the complaint or the allegations, and so I viewed him as the complainant.
All right. Had you seen any document as yet connected with the case?
No, sir.
And so do you recall when you first received Mr. Paul's name?
That would have been from Michael Wynn, when I set the meeting up to go out there and visit with him, with Mr. Wynn for the first time, Mr. Paul for the first time.
All right. Who set up the meeting with Mr. Paul?
Mr. Wynn.
And did you inform the Attorney General that you were going to also meet Mr. Paul before you met him on the 4th?
I did.
When did you do that?
I don't recall. It was within one of those days.
Would it have been the day that you talked to him about coming up on the 4th?
Yes, sir.
Okay. So did you inform him you were going first to Mr. Paul and then coming to the Attorney General?
That's correct.
So tell us about your first meeting with Mr. Paul. How did that happen and where?
So I met Mr. Paul at his office with Michael Wynn, and I drove out here early in the morning. I met with him for, I'd say, hour and a half, 2 hours, and that was the initial time that I, had heard the allegations about their complaint.
Had you done any research on Mr. Paul, his background, who he was, et cetera, before you had this first meeting with him?
I think I may have Googled his name and read a headline or something like that.
But did you limit your looking into him to Google him? Is that about the only thing you remember doing at that stage?
Yes, I didn't look at any court records or anything. I mean, that's all that I did.
And what was your level of knowledge about him when you first went to meet him on the
That he was
4th?
A commercial real estate developer here in Austin.
Okay. Did you see that he had had a search warrant executed on his house and business back in August?
No, sir.
So what was your level of knowledge of Mr. Paul at the time you met him that first time, whether you got it from the Attorney General or anyone else?
I mean, I didn't know him, didn't know anything about him.
Okay. And where did you meet him?
At his office.
Who was present during the meeting?
It was Mr. Paul and Mr. Wynn.
All right. So what happened at the meeting, without going in necessarily at this time with what he said to you, what was the nature of the bill? Who did most of the talking in the meeting?
Nate Paul did most of the talking, and it was just a lot of information given to me in a short time period.
Well, how was he doing that? I mean, how were you given
He was talking, and he was just talking, trying to tell me, the circumstances surrounding the search of his home.
Did he make any presentation to you?
Towards the end, he showed me a copy of a search warrant and an order, and that was kind of the gist of his complaint. He showed me this presentation on a PDF document.
And so if you had to estimate the time that you visited with Mr. Paul at that time to get his, whatever he wanted to impart to you, how much of that hour and a half or hour and 45 meeting was Mr. Paul talking to you?
I don't understand, like a percentage
Yes.
type thing.
Yes.
Let's just say he was talking the majority of the time. Mr. Wynn was not.
And what was your first impression of Mr. Paul? How would you describe what you saw or listened to in this meeting?
Energetic, passionate, and had a lot of conviction, kind of an aggressive attitude, just a very, energetic person.
And what was your reaction when you left? Let me ask you this. Did he basically give you his side of the matter that you had been retained to investigate?
That's correct.
And what was your reaction to it?
I mean, I was convinced by what I was shown in the search warrant presentation and all that.
So when you left, to go talk to the Attorney General, what was had you already formed a personal belief as to what you thought was going on here?
No, not a personal belief. I was just like, hey, if what he's showing me on how the search warrant was altered is true, this is a big deal.
Okay. And did you, at that time, say to anybody or think that it looks like they did some bad stuff?
I had not developed an opinion about one way or the other. I mean, that was my first time, it was kind of like drinking through a fire hose, just a ton of information coming in a short time. And when I went to Mr. Paxton's office after that, I told him it was convincing, and he agreed.
Okay. So let's move now to General Paxton, meeting with General Paxton on the 4th of September, was it?
That's correct.
How long was that meeting? Where'd you meet him?
So we arranged to meet at his office again, and the meeting was, I think, roughly 20 minutes or so.
And then what did Mr. Paxton say in that meeting?
So I told him I was convinced, it was a convincing presentation of what he agreed with that. He also said that the people in his office who were not, they weren't investigating the case, they weren't working on it. At that point I had learned that there were some federal agents and people, I guess, in positions of power who were kind of involved in that. And, he made a comment that you need to have some guts to work on a case like this. And I was fired up about the opportunity to do it.
Yeah. So how would you describe to the jury and the court your level now of excitement? Now that you've got a little bit of idea of what Mr. Paul says, you and the Attorney General have agreed is convincing, and you think this is going to be a big deal. What was your state of mind about that?
I was excited to be working on a project with the Attorney General's office.
You were already there, right?
I mean, it's the chief law enforcement officer of our state, and it wasn't about money or anything like that. It was just an opportunity to do something new in my career and try to help out.
All right. And when he said that you as people weren't working on you, did he express anything about how he felt about that to you, or tell you whether they were not working on it or they wouldn't work on it? In your own words, what did he say?
Well, I don't recall specifically, but he said that he couldn't get the people in his office to work on this case.
Okay. And did you leave that meeting with the impression or feeling that his people were refusing to work on it?
Yes.
Did you wonder, well, if they're not going to work on it, why don't you fire them?
I mean,
You didn't think about that?
No, sir.
All right. Okay. Now, after that meeting, did that meeting get terminated a little early, or tell me? You said it was about 20 minutes.
So he said
excuse me just a second. You've driven all the way up for Houston for it. What happened to shorten it a little bit?
He had to go to a press conference, and I was going to take off, and he said, well, why don't you just come over there with me to the press conference? And so I went over there with him and with one of his staff, came over to the press conference, and then after that we went back to the office. I just kind of watched the press conference.
All right, so now not only have you been hired by the Attorney General, but you're going to a press conference with him. How'd that make you feel?
Well, I mean, I've been with my dad in press conferences before on some of his high-profile cases, but it was cool.
Yeah. Okay. All right. Now, did you think anything about? Well, let me back up. So you had 20 minutes or so to talk to him about the case. Did y'all talk about any of the facts in the meeting before the press conference?
No, I did not really have a full grasp on all of the people that were involved and all the facts of the case at that point.
Now, what was your impression or belief at that time as to the occupations or nature of the people you were supposed to investigate?
I knew that they were both local law enforcement, and some of them were federal law enforcement officers at the time.
Did you know that one of his allegations was about a federal magistrate?
Yes, sir.
What was your reaction to hear he wanted you to investigate a federal judge?
My reaction to it was just hearing out their side of the story. I didn't really have an opinion one way or the other. However, if the allegations that they were making were true, then that'd be serious.
Okay. Now, did he talk about any in that conversation, any of either Mr. Paul or him, of any people other than federal and local law enforcement being the people he wanted investigated?
No, sir.
After the press conference, how much longer were you in the company of the Attorney General?
I think probably 15 or 20 minutes. We went back to his office and finished up the conversation there.
Well, what happened in that conversation?
When we got back to the office, I was a little bit concerned because at the time I'm in private practice, I think I had roughly 75 cases on my own docket, and I told him, I'm like, well, if I'm coming back and forth between Houston and Austin, how am I going to be able to do this? And he said, well, look, his words were, if you can just get a wet ink copy of the original search warrant.
Go ahead.
Well, just if what had been produced to Nate Paul and his lawyers matched up with the original copy, it would be over quickly. But obviously, if there were discrepancies between the original wet ink copy and his words, then this thing could drag out a little bit more.
So what did you think you were going to do originally then? And by the way, had you ever heard the phrase, and maybe it's very common, I had a wet copy. What is that what he said, a wet copy?
A wet ink copy.
What does that mean? What did you take it to mean?
Just the original search warrants that was signed off by the judge had, a wet ink signature on it.
Okay.
Not the scanned PDF version.
All right. So what did you walk out of that meeting heading back in the car to Houston? Did you think your mission was?
So we really didn't go into the scope of the work. At that point, it wasn't until I actually got so the copy of the contract had been sitting in my inbox. So when I get back home and I read my contract and see that the scope is limited to like more of an investigative role, then I'm like, okay, well, I'm a lawyer. I'm just going to collect evidence, review evidence that's presented to me, and draw some type of conclusion to either corroborate what the allegation is or contradict that, and put it in a brief and submit it. So I knew at that point, once I read my contract, that I wouldn't be trying a case or anything like that. It was limited in scope.
Can you put the original the contract up and go to the addendum A, please? I believe the contract is in evidence in several ways.
Is this in, Mr. Hardin? Do you know?
Pardon me?
Is it in?
I think it is.
I'm not contradicting.
I'll check.
I just
Hold
don't
on
know.
just a sec.
Could we get an exhibit number, Rusty? Eric, can you get us an exhibit?
It is in.
It's House 160 and it's in evidence.
Thank you.
Now, do you recognize this particular excerpt from the contract?
Yes, sir.
All right. And if you could scroll up just, that's going to be good. Can you explain to the jury what you realized your scope was more limited when you saw this? I take it you're saying than you originally imagined your role would be?
Just in an investigative role, and then my ultimate goal or job at the end of this would be to prepare a report of my findings and give that to the Attorney General's office, and whatever they do with it is.
And was this scope different than what you understood it to be when you originally talked to the Attorney General?
This was different than what I had, come up with in my mind, what I would be doing.
Can you tell us what lines or sentences there, Mr. Kamek, so she can highlight exactly what you noticed when you saw that it was a little bit change in the scope of what you could do?
Can I have a second or just look at this and read it?
So, for instance, do you see the sentence, if you would, and shall prepare a report documenting any potential criminal charges that may be discovered in the course of the investigation? Do you see that? And before.
So that's yes, sir. That's the report I was referring to.
Okay. And that is a more restricted role. Is it your testimony? That's really a more restricted role than you understood from the Attorney General you were originally going to have.
I'm sorry, could you repeat the
Is
question?
that a more restricted role than you originally thought you were going to have when you talked to the Attorney General?
Yes, sir.
Okay. Now, you notice it says, notwithstanding anything to the contrary contained in this outside counsel contract, outside counsel shall conduct this investigation only as consistent with the complaint referred to the OAG and is only as directed by the OAG. Correct? So who did you believe you were being hired by?
The Office of the Attorney General?
Had you had any contact with the district attorney's office?
No, sir.
Did you ever at any time during this representation think you were working for the district attorney's office?
No, sir.
Throughout your representation in this matter, whom did you think, or who hired you, and whom did you think you were working for?
The Office of the Attorney General.
All right. And in turn, throughout all of this, who in the Attorney General's office in a position of responsibility did you consistently have your contact with?
The only person I reported to was Mr. Paxton at his direction.
Okay. Now, you see, except for outside counsel's duty to provide a post-investigation report, this outside counsel contract expressly excludes legal services relating to any other post-investigation activities, including, but not limited to, indictment and prosecution. Had you yourself looked into the law that talked about the respective jurisdictions of a district attorney's office and the attorney general's office?
No, sir.
Did you ever?
No, sir.
Okay. In this particular matter, what event did you think you were going to be investigating?
The referral from Travis County DA's office with respect to this allegedly unlawful search.
All right. And then later, did you receive another referral, what's been called referral number 2?
Yes, sir.
Now, that's dated September the 23rd. Do you happen to recall when you received it?
I think I got that on 9/24.
Okay.
On an email from the Travis County DA's office.
And was that a totally different matter than you were originally hired to investigate?
Yes, sir.
When you got that, what was your response?
Well, I read through it, and I don't remember when I spoke with Mr. Paul and Mr. Wynn at the meeting, if it was before or after that, but when I got it, it was related to some type of alleged mortgage fraud where these lenders were wrongfully foreclosing on his properties and then trying to sell it at the auction. I don't recall any more detail than that.
All right. And when you looked at that one, of course, who was the complainant, the person who was complaining about the criminal conduct and wanted it investigated?
It was also Nate Paul.
Now, when you looked at it, did you see that it was essentially a complaint about civil litigation matters?
I'm sorry, could you?
Yeah, and I'm really only asking about your mindset.
Yes, sir.
Not one way the other.
Okay.
Did you notice whether it actually was a complaint about civil litigation matters in bankruptcy court?
Well, I wasn't looking at it through that lens at all. And to be frank with you, I didn't have any experience in handling any type of mortgage fraud or prosecuting any type of potential white-collar crime in that way.
All right. So did you just sort of put it aside and not ultimately do anything with it?
No, sir. That's not true.
Okay. Well, tell me in your words.
Well, I spoke with Mr. Paxton about the referral because I wasn't sure if my scope of my contract covered that.
Certainly.
And so, he said that it did. And so I was like, well, I'm going to rise to the occasion. I'm going to figure this out.
All right. So let me see if we can go through the mindset or experience for you here. You see a referral on a separate matter, which is not the one you were originally hired for, correct?
Yes, sir.
And you receive it on September 24th, and you notice it's an allegation of mortgage fraud occurred in bankruptcy court. You see that?
Yes, sir.
So how did you find out what the Attorney General felt about it? Did you call him?
Yes, sir. I mean, I'm sorry, but I don't remember the exact date.
That's okay.
But I asked him, I know for sure that I asked him if that was covered within the scope of my contract, and he said yes.
Do you remember when that conversation was and what the rest of the conversation was?
I would just have to give you an approximation. It was roughly around the time that I received the contract on 9/24, either a day before or a day after, or the day of, just somewhere in that 23 to 25th range.
And do you recall what the occasion of that conversation with him was, somewhere around the 24th of September? Did you call him explicitly for that, about whether this referral number 2 was in your contract, or were there other things that y'all talked about as well?
I don't recall the entire nature of that specific call.
Okay. Did you notice when you looked at referral 2 that one of the people that he was asking to be criminally investigated was a federal bankruptcy judge named Tony Davis?
No, sir.
You didn't notice that at that time?
No, sir.
Okay. Did that referral, just like the first referral, have a list of people that Mr. Paul claimed were people of interest?
It did, yes, sir.
All right. And did it list these people? Do you recall whether when it listed them, whether it listed actually personal data like their address and their phone numbers?
I don't recall if that was in the referral or not.
All right. Don't remember whether it was in referral number 2. Is that what you're saying?
Yes, sir.
All right. Was that the case in referral number 1?
Yes, sir.
Okay.
There were names and I believe some demographic information.
All right.
The first one. I don't recall.
Now, in referral number, I mean, let's go back now to the period a little before September 24th, when we were talking about the original referral. After you returned, did you receive any type of documents and materials to review when you left the meeting with both Mr. Paul and back on the 4th of September?
Yes, sir.
Can you tell us what kind of materials he gave you that you took back to Houston to review?
So I had taken my handwritten notes from the meeting back with me. And then I also received like a little 5 or 6 page document that appeared to be some type of timeline of events giving Mr. Nate Paul's version about what happened.
All right. Now, did you take that just as his version?
Yes, sir.
All right. But when you left there, what did you have when you left there, and then on the 4th, and after your meeting with the Attorney General, had you developed sort of a game plan in your own mind as to how you were going to do the investigation?
So I did. I was trying to consider, how to get information to either corroborate or contradict what was being said.
All right. And did you tell us how you viewed the role of Mr. Paul and his lawyer, Mr. Wynn, in this, in terms of what role were they to play in the upcoming investigation?
Well, I viewed Mr. Paul as the complainant. He's the one who was complaining of these allegations, and then, Mr. Wynn was his attorney in some other separate matter.
How did you view your role as the Attorney General? Did you look at them almost as a client in terms of them sharing information with you and all? How would you describe that in your own words? With who? Mr. Paul.
Okay.
And of course, Mr. Wynn's his lawyer. But in your view did you consider yourself as like a prosecutor and a citizen had come in and made a complaint?
I viewed him as a complainant in the case, and just in the same way that if a client hires me for a case and they bring in a banker's box full of documents and information, I'm going to go through it. And so I didn't think that it was unusual that I would be getting information from the complainant and his attorney. And as I got that information, I thought this was the same information that Mr. Penley had.
Yes. Had you met Mr. Penley?
No, sir.
Did you ever meet him?
No, sir.
All right. So when you originally were hired by the Attorney General, Did you make a certain assumption as to what your role in Mr. Penley's would be?
Well, I thought I would meet Mr. Penley at some point. I remember I asked Mr. Paxton in that first or that second meeting if I'd be meeting, am I going to talk to him? Does he have a file that I can start working with? And his response was, I think he was out of town and he had a file on his desk. So I did assume at some point that I would meet Mr. Penley and take a look at his file.
Well, did you assume originally that you would be working with the Attorney General's staff as you gathered information, and that would mean that you'd be working with the division head?
I did. I mean, obviously, as a solo practitioner, I don't have access to a lot of the resources that government offices has. And so I thought at some point I would be dealing with or meeting with some of these individuals.
Right. And so did you just assume that Mr. Penley was being kept informed as what was going on here?
I didn't really think about that at the time.
Okay, fair enough. But at any time, how many times did you ask Mr. Paxton about either meeting Mr. Penley or getting some information or getting some support from the Attorney General's office?
I'm sorry, I didn't understand the question, Mr. Harden. Can you repeat your question, Rusty? I didn't hear it. I'm sorry.
Sure. How many times did you ask Mr. Paxton about either meeting Mr. Penley or getting some information or getting some support from the Attorney General's office?
Thank you.
I asked, it's kind of two parts. So with respect to Mr. Penley, I'd only talked to him about Mr. Penley maybe twice, and then that was early on, and then that's when I was asking about, was there a file, and how do I get in touch with him on this deal? And then as far as getting support from the office, I think I asked probably 4 or 5 times over the course of this 3.5 week period when this all happened, can I get badge, can I get credentials, which I never got, but I repeatedly asked for those things.
And what was the Attorney General's response each time?
I think initially his response is, okay, we'll have to get somebody to work on that, or we'll get it to you. It's just I never got a firm answer on when I would be getting those things. I knew I would need it when it came to issuing subpoenas and things like that.
Yeah, so what things were you asking him for? Let's start with Mr. Penley. Each time that you asked him or mentioned Mr. Penley, did he have some reason not to put you in touch with Mr. Penley?
The only thing that I asked about Mr. Penley was, did he have a file and will I be meeting with him? To which his response was, he's out of town and his file is on the desk. I just thought in my mind that I would eventually meet with him to discuss this case. I mean, I don't know anything about any of these people in that office, and so I'm like, I didn't know anything going on. So
how did you know Mr. Penley? Just looking at a flow chart? How'd you know about him?
I knew the name from Mr. Wynn and Mr. Paul in that first meeting.
Did Mr. Wynn and Mr. Paul, were they critical of Mr. Penley in that first meeting?
Yes.
What'd they say?
Well, they said that Mr. Penley said that there was no information that could be presented to him that would make him believe that a federal official broke the law in the way that they claimed.
All right. And this conversation with them was that was the one September 4th?
Yes, sir.
Okay. Now, do you think that's a little strange that they didn't want to deal with the head of the division in the Attorney General's office?
My understanding was that they had met with him one time.
That's all, just one time?
Yes, sir. That's what I was told.
Is that what they told you?
Yes, sir. And he refused to look into it. And then that was kind of reinforced by the fact that Mr. Paxton said that he couldn't get anyone in his office to work on the case.
All right. So in your conversations with them and as your investigation, were you ever told or informed that they actually met with Mr. Paul 3 times?
Excuse me, Your Honor, that them, objection hearsay, that includes other people other than Mr. Paxton.
Sustained.
Let me ask you this. Did you ever learn from Mr. Paul, Mr. Wynn, or Attorney General Paxton that Mr. Penley...
Excuse me, same exact
Let
objection.
me just finish, please.
I'm sorry.
That Mr. Penley or Mr. David Maxwell met with Mr. Paul and Mr. Wynn 3 times.
Okay, that's both multifarious and hearsay.
Sustained.
Did you ever learn that Mr. Penley, did you learn anything from any source about how often Mr. Penley was trying to get Mr. Wynn to provide further documents?
Objection.
Objection is only was he aware of anything like that?
Objection, hearsay. The question was, did you learn from any source? Objection, hearsay.
I'm only...
Overruled.
Thank you. Were you?
I'm sorry, could you please repeat the question?
Sure. Were you ever aware from any source that Mr. Penley, after 3 meetings, was continuing to try to get documents from Mr. Wynn? Did you ever hear that from anybody?
Objection. I'm sorry. Objection,
sorry.
hearsay. I apologize. Sorry, Mr. Kamick. Sorry, Rusty. Objection, hearsay.
Sustained.
In your mind, what was your understanding from any source of the level of involvement of Mr. Penley and Mr. Maxwell in this investigation?
I'm sorry, Rusty, the level of...
I'm not asking for any statements or anything. I'm asking what his understanding of mindset was.
I understand. I just didn't... You said the level of, and then the word trailed off. I'm sorry if I'm being difficult.
How sorry are you?
Pretty sorry. Sorry enough.
All right. My question, I think, stands, Your Honor. I simply want to know what his state of mind and level of knowledge was, because it has a lot to do with what he does later.
Yeah, I didn't hear an objection, actually. I just heard him say...
I didn't either, so...
He just said he couldn't hear you. So.
I just didn't understand the question. That question, as asked, I'm fine. Go ahead.
Is your microphone on?
Well, he's reading it. I can't read that far. Go ahead. I'm sorry.
Thank you. Now, at the end of the day, what was your level of knowledge about this?
So I was told early on by Mr. Paxton that the people in his office weren't doing what he asked them to do. That's why he was considering hiring outside counsel.
Right.
And then towards the end of September, in this 3.5-week period, I was told by Michael Wynn that Mr. Penley had reached out to him kind of out of the clear blue for documents. And then I asked Mr. Paxton about that when I spoke with him, and he said, well, I told him to stand down. He's not working on this case. You are.
And who should stand down?
Mr. Penley.
Yeah. General Paxton told you Mr. Penley should stand down. He wasn't involved in the case anymore?
That's correct. And that was my only other time that I knew about any of his involvement.
All right. Do you recall when that conversation was and where you were?
It would have been a phone call towards the end of September.
All right. Thank you. Now, let's go back after the 4th. I assume you started reviewing the materials you had received?
Yes, sir.
Tell us about how you proceeded in your investigation then.
All right, so still trying to get my arms around what was alleged and all of the folks that were involved in it, and trying to figure out, since I didn't really have any information, what information I would be able to obtain. And just started kind of thinking of the way to do this would be to do grand jury subpoenas to get information regarding like phone calls and things between the individuals involved in that first referral.
All right. Now, by the way, did you during this period of time, Mr. Kamick, consult with any other people you thought might have had these types of investigations before to sort of get an idea how to proceed?
No, sir. No,
this
sir.
is not something you had done before, correct?
I had not ever done this before.
Okay. Now, by the way, in your communications with the Attorney General, how were you communicating with him? By phone, by text, by email? Can you describe the forms of communication y'all used?
So we spoke by phone and through text message, and then throughout this process, I continually forwarded emails to him as something would come up or I would get some information.
Well, did you use any kind of encrypted communications?
Yeah, I think about the middle of the month, he asked me to use the Signal app, which I wasn't really familiar with at the time. I just thought it was like a WhatsApp or just a messaging
You were unfamiliar
deal.
with Signal app at that time?
I'd never used it before.
All right. And how did that come about that he wanted you to communicate with him using Signal app?
He asked me on a phone call to download the app and use that.
Did you go on the internet to look and see what a Signal app was?
No, sir, I just downloaded the app.
Okay. And do you recall what the nature of the conversation was in which he asked you to start using Signal app?
It would have been a call where we were talking just generally about the case, kind of the status of it and what was going on. It wasn't I do remember it was not a phone call specifically about using that app.
And what type of email address did you use with him?
But what do you mean?
Well, do you recall what the email address was?
No, sir.
Was it an official Attorney General's office email address?
Oh, I see what you mean. No, sir.
All right. What was it?
His email address was a Proton mail address.
All right.
That I was given.
Had you used Proton before?
No, sir.
Had you ever heard of Proton?
I had heard of it. I've never used it.
Okay. Now, in addition, what about the phones? What type of phone number did you have that you would communicate with him?
I had the original number that he had first called me on, and then I think later he gave me another number. Around that time, I was getting calls from unknown numbers, or it'd say potential spam. You know, you get those types of calls, and I was like, well, I don't want to miss the Attorney General's number, so I got myself a separate number and gave it to him. That way I knew when that phone rang, that was Mr. Paxton calling.
So are you saying that you ultimately got a phone that was totally dedicated to phone conversations with the Attorney General of the state of Texas, and that's the only number that you communicated with on that phone?
Yes, sir.
And you did that why?
Because I didn't want to miss a call from an unknown number or a spam likely call, or, you know, when you get those spam calls, I didn't want to have that come up and miss an important call. So
did he use multiple phone numbers with you?
Yes, sir.
How many?
2 numbers.
Okay. And were either of those official Attorney General lines?
I believe they were cell phone numbers. I don't believe they were office numbers.
All right. In fact, when was the first time that you ever learned what the official email address or the Attorney General office email address was of the Attorney General that you were dealing with all this time?
The first time that I ever saw his governmental email address
Yes.
was when I got a cease and desist letter from Jeff Mateer.
And when was that?
That would have been, I believe, August 1st or 2nd.
And how was it that you saw what the Attorney General's official email address was?
They were all copied on the email. All the gentlemen, Mr. Vassar, I think, was one of them. And
was that first time when you got your cease and desist letter, the first time you ever knew of any official communication form of communicating with the Attorney General, whether it was through text or email or phone?
I thought all of my communications with him were official, but that was the first time that I saw his governmental email address.
All right.
Yes, sir.
Now, did you trust the Attorney General?
Yes, sir.
Were you flattered about him reaching out to you?
Yes, sir.
Did you trust Michael Wynn?
Yes, sir.
Did you appreciate him referring you to the Attorney General?
I did. Yes, sir.
Okay. And did you always trust Michael Wynn to have your best interest at heart and try to help you?
Yes, sir. I didn't have any reason not to trust him. I knew that he was Nate Paul's lawyer.
Okay. Did you trust Nate Paul?
Didn't really know Nate Paul. Just was trying to do my job.
All right. Now let's move to the period of the middle of September. After you came back, you had all your material from the 4th that you had gotten from Nate Paul. What did you do after that?
So around this time, I had a conversation with Mr. Paxton because I wanted to try to get the individuals named in that first referral, like call logs and email logs showing whether or not these people had been talking around the time that the search had taken place. And so, being that it's sensitive, since they are federal agents and there's some people in power there, I thought that the grand jury subpoena would be a discreet way to get that information. And so I brought that up to Mr. Paxton.
And do you recall when this conversation was?
I believe it was around, we had talked about it from early on in the month, like within that first week of September, but the conversations kind of continued going on until about the middle of the month, about September 14th.
Okay. Now, at that time, what did you say to Mr. Paxton, and what did he say to you?
I told him I think we should try to do a grand jury subpoenas, being that this is a discreet way to get information. Grand jury proceedings are private and secret proceedings, and so we'd be able to get information that way without raising any kind of alarms or causing some type of, panic about the situation. And he said it was a smart idea.
So he endorsed it?
Yes, sir.
Did either of you talk about the fact that if you issued grand jury subpoenas for a claimed offense that Mr. Paul was presenting to you, that the recipients of those grand jury subpoenas would know what was going on, or have questions, or be maybe even alarmed? Did y'all discuss that at all?
Excuse me, objection leading.
I think I gave him several
Sustained.
choices. Did y'all talk about the possible reaction of people that got these subpoenas?
No, sir.
Later you issued subpoenas, did you not, for credit unions and banks and stuff like that, correct?
Yes, sir.
Was there any conversation between you and the Attorney General about how those people might feel when they got those grand juries?
No, sir.
Did you become later aware, we'll get to who all that were on there, of that some of these subpoenas were going to lawyers or people that were opposing Mr. Paul in litigation? Were you aware that that's who some of the people were?
No, sir.
Okay, well then let's get to what you know. When you talked to the Attorney General back about downloading the app and everything, were you also talking to him at that time about trying to seek credentials and other types of things that you needed for what you were doing?
Yes, sir.
When did you first start asking for those types of things?
In my first meeting with him on September 4th, and then I asked about it again, like as I'm approaching the time where I need to be, as the time I'm doing the applications for these subpoenas.
What did you ask him for?
Email address, am I going to get some type of badge or some credentials, because I'm going to be approaching people with legal documents, and I need something to show that I have the authority to do that.
What did he say?
We're working on it.
Now, you assumed, did you not, that of course it'd be perfectly fine to give you those things because it would be a public record and there was nothing wrong with it, correct?
I expected to get that.
Yes. And you expected and believed you were going to need that, did you not, in your investigation?
Yes, and I ended up, I did need it.
How many times do you think you asked the Attorney General for these official documents?
It would have had been 4 or 5 times over the course of a month.
And each time you asked him for him, what was his response?
We're working on it. We'll get it to you.
At some time, did you begin to wonder why they would not give you any kind of official documents to show your status?
No. I don't know how the office operates within the Attorney General's office. I wasn't sure if there was a bunch of red tape to go through. I didn't know any of that. I just knew that I would need it to do what he was asking me to do.
Right. We always hear about the slowness of bureaucracy and government agencies. Is that the kind of thing you just thought was going on?
Yes, sir.
Okay. So it never occurred to you that maybe he didn't want them to be public?
Objection, leading and assuming facts not on evidence.
Sustained.
Did it ever occur to you? Did you ever have the thought, a wonder, don't they want this public or what? Did you have that kind of thought process?
I wasn't thinking about anything like that.
Fair enough. Now, when you mentioned the grand jury possibility to the Attorney General, in that conversation, and you think that conversation was when, roughly?
That would have been around... I know I spoke with him about it on September 6th. So I have a note here on this invoice, but the middle of the month around September 14th.
Okay.
There were a couple conversations where I was just kind of trying to figure my way through this.
Now, you, of course, as you mentioned before, had never done a grand jury investigation, correct?
That is correct.
So did you ask him some questions, to the Attorney General, some questions to try to help you in that respect? First of all, did you assume that maybe he would know that kind of answers?
Yes, sir. I am so sorry. Judge, is there any way I can use a restroom break?
We'll stand at ease for 10 minutes.
Sorry about that.
We'll give you 10 minutes. The witness may step down.
Thank you, Judge.
Okay.
Thank you very much.
I would just stand at your desk, George. I would not leave. He's just stepping out and coming right back.
And so we've been listening to the testimony of Brandon Kammick, who was hired by Attorney General Ken Paxton to serve as he says, special prosecutor for the office to look into the claims from Nate Paul that there was a sort of conspiracy against him in order to carry out these search warrants of his properties. I'm joined now by a local Austin attorney who has been with us all morning. Mr. Wood, we appreciate you being here with us to tell us your take on some of this. I find some of what Brandon Kammick had to say, quite damning for him to say that he was hired and he had never carried out
it's really hard
an investigation like this.
I think one of the most poignant lines that we heard from him in his testimony so far is he said it was kind of like drinking water out of a fire hose. And looking at this, young, relatively inexperienced attorney at only 5 years in practice, working on behalf of the Attorney General of Texas on a private matter, that's a lot to carry for a 5-year lawyer.
Well, and that he seemingly was hand-picked, right? That the Attorney General Ken Paxton told him, quite frankly, point blank, and remember, he's testifying under oath, that Michael Wynn, Nate Paul's attorney, had recommended him for this position to be a special prosecutor to look into these claims. This is not good for the defense.
Of course not, because the Attorney General of Texas, we've mentioned this, is the top law enforcement officer in Texas. You would think that he has the resources to go to any experienced lawyer he needs, and not to mention all the lawyers in his own office. And
who said, we don't want to do this?
Right.
And you're looking at Article 5 on your screen there. This is so what Brandon Kammick is speaking to is directly related to this article against him. So Article 5 is disregard of official duty with the engagement of Kammick. And Ken Paxton is accused of misusing his official power by violating the laws on appointing prosecuting attorneys for the Attorney General's office. It's not as though the Attorney General can hire whomever he wants. There are laws dictating how the Attorney General's office hire its appointments. And not only that, but that Brandon Kammick was hired specifically to investigate this, what the House prosecutors call a baseless complaint. Again, that's this complaint from Nate Paul that resulted in 30+ grand jury subpoenas. I think one of the things that stood out to me, and James, you tell me if you feel differently, is that Brandon Kammick looked at this allegation, this kind of idea that the search warrant of Nate Paul's properties was changed on the spot. That is what Nate Paul, this is the conspiracy that he formed against, in his mind, that they were looking at his properties, that they initially went in and raided his properties looking for drugs and guns at 9 a.m. And at 11 a.m., when they didn't find any of that, they switched the search warrant right then and there to say, oh, white collar crime. That's what we're looking for, that they changed it on the spot, and that this sort of thing would include a federal magistrate to be involved, federal attorneys to be involved, and certainly those federal agents, but that this whole conspiracy. And so the other experienced attorneys in Paxton's office said, that's not even a thing. Right. Like, it's not, there's no way that happened. They called it, quote, insane.
Yeah. Well, I'm always on guard because when we get calls to our office for people saying that they need to sue the federal government, this judge, that judge, and the attorneys, that's usually a really quick sign that there's something wrong with the person calling. And I've gotten calls like that many times over the years, and this one played exactly like one of those. And so for the Attorney General of Texas to hear that and be involved in it doesn't make any sense to me.
And obviously, you know, we're hearing certainly the witness testimony that Paxton himself felt like he had been wronged by federal officials, and particularly DPS even, in the indictments against him. And that's why he wanted his attorneys to take a look at this. Brandon Kamek back on the stand from that bathroom break, and the court is being called to order. You can see we're waiting for the senators to take their seats as we will continue with this testimony. Certainly damning testimony from Mr. Kamek is starting again now. So let's go ahead and take a listen in as we're watching that final senator take his seat there. Let's listen back in.
Looks like we're short 2 members.
Well, I say let's listen back in. Nope, we got to wait for 2 senators to take their seats.
I picked up a lot on Rusty Hardin going in directly for which email addresses we're using, which phone numbers we're using, and
how were you sending text messages?
It was offline.
Well, and that he's certainly saying he should have known. None of the emails were from the official website. He got his own phone that he only gave to Ken Paxton. They were using a app to send text messages at Paxton's request. That's encrypted text messages. But would you be able to get these things over on a young attorney compared to a more seasoned attorney? Your opinion?
That's my opinion, is that this was a handpicked to do whatever he was told to do. And we heard him testify that he was excited and fired up about working for the Attorney General of Texas, like most young lawyers would be.
And that he trusts Paxton, so you wouldn't think that Paxton was telling you to do something that you shouldn't be doing.
We're one juror short, so we're gonna wait.
It was also very strange to hear that this lawyer got a different phone with a different phone number and used it exclusively for communication with Paxton. That tends to lead me to believe that there might have been an inkling that you'd want that kept off of your other records.
And he said he did it, this is him saying not that he was urged to do it by Paxton, but that he decided to do it because he was getting so many spam calls, which, look, I get a lot of spam calls myself. He said he didn't want to miss one of Paxton's calls because Paxton called him from different numbers.
Right. And, my instinct would be just if you're expecting a call from the Attorney General of Texas, go ahead and answer those numbers you don't know just for a short time. So getting in separate phones seems really strange to me.
Yeah. Questioning resuming. Let's listen back in.
I want to go to, if I may, when you were asking him and talking to him about the grand jury subpoenas. During that conversation, and you mentioned that you asked him about credentials. How did you go about trying to find out how to do a grand jury issuing and using grand jury subpoenas? What did you do? Your microphone.
Yes, sir. So I asked Mr. Paxton, it's, at this point, he's like, this is a smart idea. This is the way that we should proceed. So the next question is, okay, well, how do we do this? Because I wasn't sure whether the Attorney General's office had their own special grand jury in session for cases, or if we would do it through county, like Travis County grand jury. And so I didn't know the answer to that. He said he didn't know the answer to that. He would need to find out. And, I think he had indicated to me at that time, he wasn't a criminal lawyer. Most of his experience was in business law. So he would find out which grand jury that we would.
And did you find out?
He reached back out to me around the middle of the month, maybe a day or so after, and told me that we would be going through the Travis County grand jury.
But the AG himself called you back and told you that?
Yes, sir.
And then what did you do? So
my next step was to reach out to Travis County District Attorney's Office, and it was kind of weird because before I even have an opportunity to do that, I get a message or a voicemail that Michael Wynn had sent me saying, this is the person that you need to contact over there.
How soon after you had the conversation with the Attorney General that concerning the fact that it would be a Travis County grand jury, how soon after that conversation with the Attorney General did Mr. Wynn reach out and give you a contact in the Travis County DA's office?
I don't recall exactly, probably within 24 to 48 hours.
Do you have any idea how Mr. Wynn would have known that you were seeking that information?
Well, I'm sorry.
Had you told Mr. Wynn you were trying to find out, or did they just come in unsolicited?
No, I spoke with Mr. Wynn about the grand jury process.
All right.
So he was aware. Him and Nate Paul were both aware that that's how I was proceeding with their investigation.
When you got that information, did you reach out to the Travis County grand jury?
I reached out to the Travis County District Attorney's Office and spoke.
Excuse me. I said grand jury. You're right. The office. Excuse me. Go ahead.
I spoke with. I forget. It's a nice woman. I forget her name. She put me in touch with a gentleman named Don Clemmer. And then Don Clemmer put me in touch with, I guess, this real sweet lady. I think her name was Bailey. She might have been the grand jury coordinator over there.
Let me ask you this. Was it last name Mulder? Does that sound?
That sounds like
all
correct.
Right. Did you tell these folks that you were a special prosecutor working with the Attorney General's office?
Yes, sir.
Okay. And as such, you were asking assistance to get some grand jury subpoenas?
Yes, sir.
And did they help you get the grand jury subpoenas?
Yes, sir, they did.
And let me ask you, at this time, Your Honor, I want to move to introduce en masse, I believe we informed counsel on the other side, Exhibit 257, which I'll represent as all of Mr. Kamak's production in this matter to both sides. These are the documents that he has produced to lawyers on both sides, and I move to introduce them in toto.
Any objection? Speak on the microphone, please. Still can't hear you.
Object to 649, 691.
Dan, can I stop you for just a second to explain to the court? We have given them excerpts. It was too voluminous to be carrying around the hard document here. But what we did do, about 2,000 pages, I think it was a lot. What we've then I've gone through and taken out excerpts and put an exhibit number on them. But they are excerpts from what I was seeking to do was introducing the whole group and then taking out and putting an exhibit number on those that we specifically were going to talk about. Go ahead.
I appreciate all that, Mr. President, but to be clear, we got an amended exhibit at 4:50 this morning, which includes these, several of which I will be objecting to, several of which I won't.
Excuse me, are we going to start getting into when we get stuff for them and what time of the morning? I would just ask for
just stop right now.
Yeah.
You would, like I started to say, object to 649, 691, 687, 688, 689, 690, 686, and 650.
Reason for the objection?
Sir?
You objected to those documents, okay?
I am. Now,
Okay.
I do not have objections to 677, 678, 679, 680, 681, 682, 683, 684, 685, and 693. The last sequence, Mr. President, I do not have an objection to.
So let's go back to the objection.
Yes, sir.
I'd asked you for a reason for the objection to the
Yes, sir.
other documents.
Yes, sir. The basis is hearsay on each. And just so let me try to get them in order so Mr. Harden and I can literally be on the same page.
May I ask one more time real quickly the ones you object to, Dan?
Sure.
To make sure I got all of them.
Yes, sir. The ones I'm objecting to are in order, Rusty, are 649. That's the work product. If you're with me, you want me to come over there? I'm happy to do that if that's easier for you.
No, go ahead.
649, 650, 686, 687, 689, 690, and 691.
And the type of objection, Your Honor, the basis?
Hearsay. And I don't know if you, Judge, do you have, Mr. President, do you have them in front of you?
We don't have them.
May I do this? May I do this? Let me go right now to discuss the ones that that has no objection to and ask that they be admitted.
Sure.
Okay, we'll admit the items that you have no objection to, and to be certain we have those right numbers, would you repeat those numbers that you do not object to?
The numbers that and I'm not sure these are in order, but 677, no
Yes.
objection.
Okay?
678, no
Yes.
objection. 680, 681, 682,
Yes?
683,
Yes?
684,
Yes?
685,
Yes?
and 693.
What about 679?
All right.
Hold on one second. Just checking this.
You inquired on
but
679. I don't have that one in front of me.
Okay, you originally said you had no objection to 679, but you may have misspoken.
Certainly capable of doing that. No, you're correct, Mr. President. 679, we do object to 679.
Okay, so 679. So to the court reporter, and forgive my for a moment there, something I said the witnesses shouldn't do. So to be clear to the court reporter, no objection to 677, 678, 680, 681, 682, 683, 684, 685, 690. You will just focus on those. And if you want to refer to the others, you'll have to give us an answer on why it's not hearsay at that time.
That's correct. Your time, could I?
I'm admitting, so we are admitting into evidence 677, 678, 679, 680. I'm sorry, 677, 678, not 679 at this time. 680, 681, 682, 683, 684, 685, and 693.
Your Honor, can I have 10 minutes credit back because of the housekeeping we did here?
Did you say you needed 10 minutes?
Could I have 10 minutes credit back for the conversation we've
I'll
had?
give you 5.
Thank you.
All right.
All right. One has to take what they can get. All right. Mr. Kamek,
Yes, sir.
did you start receiving assistance to get these grand jury subpoenas done as to who they would be from Mr. Wynn?
Yes, sir.
And is it still on? I didn't hear. Yeah.
Can you hear me?
Yes.
Okay.
Yeah. All right. And what form of assistance were you getting from him?
Well, I started to get a lot of information from Mr. Paul and Mr. Wynn through emails. That included the list of individuals who were, I guess, suspects or somehow witnesses or somehow related to that first initial referral.
And were these people that were to be put on the list of subpoenas?
Some of them were, yes, sir.
All right. And were you receiving from Mr. Wynn regularly information of people to include on the grand jury subpoenas?
Yes, sir.
Now, what was your thought process in terms of your investigation as to why you would automatically put those people on if they're asking. In your mind, you were doing what?
Well, I didn't independently source any of these individuals' name. I walk into this referral, and I'm given a lot of information about different people who were involved and how they may be related to that first referral. And so I trusted that that was the information that that they were giving me was the same information that the Attorney General's office, Mr. Penley, would have already had to conduct his investigation.
All right, so you assumed that you were just getting information that already existed?
Yes, sir.
In the hands of the the AG?
Yes, sir.
But you hadn't talked to anyone in the AG, correct?
Other than Mr. Paxton, that's correct.
All right. And each time that you had a course of action in this case and thought you were going to do something, did you have a practice of contacting the Attorney General to update him?
Yes, sir.
And so as you went along and gathered all this information from Mr. Wynn and Mr. Paul, were you keeping the Attorney General informed of all this?
Yes, sir. I would discuss it on the phone, or anytime I got like a document emailed to me from Mr. Wynn, I would forward that on to the Attorney General's email address. And then when we spoke again, if we did, I would say, hey, I sent you this or sent you that.
So let me see if I understand. Whenever you received information from Mr. Wynn and or Mr. Paul by email, you would then forward that information to the Attorney General?
The majority of the time, yes, sir.
All right. So when they were sending you list of people that should be subpoenaed by the grand jury, were you making sure you kept Mr. Paxton informed of that?
I'm sorry, do you mean if I sent that information to him, or just letting him know that I received that information, or?
Just letting him know that you received that information.
Yes, sir.
All right. So would it be an accurate statement that as you proceeded in this, well, let me put it another way. As you proceeded in your investigation, and as you determined what to do with the grand jury and what to do about grand jury subpoenas, were you at each stage keeping the Attorney General informed?
Yes, sir.
At any time, did the Attorney General contact you and say, no, don't do that?
No, sir.
So from your own state of mind, in every single thing you did in this investigation, what is your testimony to the jury as to whether you believed you had the full support and agreement of the Attorney General of the state of Texas?
That's true. I did everything at his supervision, kept him informed on everything. When I reached out to Travis County District Attorney's Office and introduced myself regarding the grand jury subpoenas, I got affirmation the entire time that everything was good, and no one said anything different until I, got a cease and desist letter at the end of.
And so it was one of your frustrations that you didn't have anything official to tell people that's what you were doing. Is that correct?
That's right.
Excuse me. Objection leading.
I'm sorry.
Well,
Sustained.
were you frustrated about the not having any identification and documents and means to tell others in the outside world?
Yes, because yes, sir.
All right. And what was the reason? What was the reason for being so frustrated?
For example, when I had some subpoenas issued for Microsoft, and I got an email back saying, without a governmental email address, we can't execute these subpoenas. So I knew that as I'm continuing to work in the course of this deal, that I would need to have some type of identification, whether it's a governmental email address, some number. I don't know what their processes are, but I knew that I would need some type of credential to be able to do what I was asked to do.
What were you subpoenaing Microsoft for?
Email records, I believe, for certain individuals that were involved in that first referral.
All right. So in the first referral, you were seeking email information, everything from Microsoft about all of these individuals?
Whoever had an Outlook email address.
And in addition to the people involved in the execution of the search warrant, were you receiving from Mr. Wynn other names that should be added in?
I don't recall all of the names that were on the list.
Oh, yeah, I'm not asking you what the names were, but were you receiving, during this time that you were conducting an investigation, continued list and suggestions of people to investigate and to list a grand jury subpoena for?
Yes, sir.
And at this stage, did you reach a stage of discomfort that you were getting all this information from the lawyer of a man that you knew was already under investigation by law enforcement?
I didn't know that Mr. Paul was under investigation at the time. I knew about the search, obviously, but I didn't know that he was under any kind of, at the time, it would have been a current investigation. And then just with respect to Michael Wynn, I had no reason not to trust that Michael was giving me information that he had already collected and that I thought that the Attorney General's office already had. So I thought that whatever he gave me was for the purposes of investigating that referral.
Okay. I want you to look. I'll put some hard copies up there for you. It's in
Yes,
evidence
sir.
now. Exhibit 678.
678.
And it's going to be Bates stamp. Well, do you need the Bates stamp? No. Okay. Thank you. Can you tell us what that is, please?
So this is an email that I sent to Ryan Vassar with this is the same day that I met with Mr. Paxton on 9/4. And when I got back home, I signed the draft contract that they sent me and sent it back, and I asked for an executed copy back. Mr. Vassar had asked me to see if there were any kind of conflicts, so I reached out. I didn't have any clients that had any cases pending where the AG's office was opposing counsel, and I reached out to the State Bar Ethics Hotline and said, hey, is this okay? I don't have any cases pending against them, and they said, it's fine, congratulations on the job.
All right. I'm trying to look at these subpoenas in terms of what's admitted, and I want you, if you would, to turn to 681. I'm only going to ask you to not put it up because I believe that's one no, that is one that's in evidence. Can you help me out? Look at 681 and identify this for the jury, please.
So this was an email from me to Michael Wynn, and it says sample form grand jury, Google grand jury subpoena.
All right. And then look over to why did you send it to Michael Wynn?
Michael Wynn had initially, so I had never issued a grand jury subpoena before.
Pardon me?
I had never issued a grand jury subpoena before.
Right.
And so I asked Michael, once I put this draft together, if you take a look at it, it's the same information that they had already given me, and make sure that the form here is correct.
And so Mr. Wynn respond to you and tell you it was okay?
He said, form is fine.
And then at the end of the day, what did that help you do?
What did it help me do?
Yes. Did that help you decide how you were going to do the subpoenas and what language you were going to use and everything?
I sent this to him. I mean, I knew he was a federal prosecutor at this point in the past, Harvard educated. I just sent it to him does the form look okay here? So it helped me to know that this was the right way to do it.
All right. Your Honor, I'm looking here. I was having to order up the ones they've objected to. And there are some of these that I very much want to get into evidence. And I don't believe there is a legitimate objection. I'm trying to figure out how to handle this without taking any undue time now. But for instance, if I could, do we have hard copies for the court, Stella? Of these exhibits, do we have any more stacks? Do you have before you 691 without saying anything about what is in context? I want you to identify it for the record and tell us what it is.
Mr. Hardin, you said 691?
Yes. I wrote that down as one you objected to.
I don't have a 6. Oh, I do too. I stand corrected. Thank you.
We have that on the list you objected to, correct?
Yes, sir. I'm sorry.
Well, we're waiting for us to see it. We don't have a copy before we can rule.
Yes, sir.
All right. You see 691, would you, without talking about the internal contents yet, would you describe what that document is?
This was an email from Michael Wynn on September 21st, 2020, with an attached Excel spreadsheet that appears to have individuals' names listed there with various demographic information.
Does it list names, addresses, and identifying data that have been blacked out for purposes of this exhibit? But does it list names, addresses, and personal data of people to be investigated and included on the grand jury subpoena?
Yes, sir.
All right. I don't understand what the objection was to that, Your Honor.
The
Well, give us, go ahead, I'm sorry.
The objection is hearsay. It's not a list created by Mr. Kamek, but by Mr. Wynn, and it is being offered for the truth of the matter asserted because they're going to...
Your Honor, go ahead. I'm excused if you were talking. No, I thought you were through. Go ahead.
That's okay. It is going to be offered for the truth of the matter asserted because they're going to be arguing that these were the names ultimately where subpoenas were being used on. So objection, hearsay.
There are a series of these, Your Honor, that first of all, not offered for the truth of the matter, only that was provided to them. We are not suggesting that these people should be and were witnesses for the grand jury, should have been a grand jury subpoena. But the more important part is, Article 16 is a conspiracy article that says that General Paxton engaged in conspiracy with others. We are not alleging that they engaged in this conspiracy with Mr. Kamek. We are alleging that he engaged in a conspiracy with Mr. Paul and Mr. Wynn. And any statements that are made in pursuant of that conspiracy would be admissible, whether or not it is hearsay. It's an exception to the hearsay rule. I know I am springing that on the court. You might want a moment to think about it or so, but that's why, A, it's not hearsay, but B, even it it is an act in furtherance of the conspiracy.
They are admissible through the testimony of a co-conspirator, not through Mr. Kamek, who Mr. Hardin admits is not a co-conspirator.
Give us a moment.
Pardon me? Okay.
And just, Judge, Mr. President, while you're considering this, I would, based upon Mr. Hardin's argument for the admissibility of it, there is no suggestion that General Paxton created or participated in the creation or the assimilation of this exhibit.
Okay, give us a moment.
And we're continuing to hear testimony from Brian Kamek. He is the Houston attorney who was hired as a special prosecutor to investigate claims that Nate Paul was bringing forward concerning corruption within the FBI and other federal investigators.
Brandon Kamek.
Oh, did I say Brian? Excuse me.
So there's so many names to keep track of at this point. Certainly significant testimony from Mr. Kamek about how he was carrying out this investigation into Nate Paul's claims is really at the direction of Ken Paxton.
I mean, that is why he is such an important witness for the House, really establishing that each and every step that he took was at the direction, the behest, or at a minimum, the approval of Attorney General Ken Paxton.
And they're talking now about whether or not they want to admit some evidence, some correspondence that Kamek was having, and you can see Judge Lana Myers is advising Patrick on these decisions.
As you said, Mr. Hardin,
let's
you didn't
listen.
mean to spring this on the court at the last second, but it is to us at the last second. I think this is a good time for a lunch break.
Sure.
And give us a chance to review all of this.
And just for your edification, Mr. President, I think the majority of these, I think, Rusty, correct me if I'm wrong, but I think the ones we're objecting to are very similar to, our objection to these is going to be consistent with the majority of the other ones that you want in, right?
That was going to be my next question, is the objection on all of these
I don't
the
know
same?
all of them, but most of them.
Most of them.
Yeah, his objection would cover those, and our response covers all those that were kept out in his records.
Okay.
Thank you.
We may reach out to you during the lunch break. We may not, but we'll come back at 1 p.m. The witness can be excused till 1 p.m. You want to be back at 1?
And we
And
also
counsel,
want
can you
to
both come
bring
up before
in
you
a
all
special
leave for lunch
guest
break?
we have had this morning, Austin Attorney James Wood, who's helped us very eloquently and astutely sort of deconstruct some of what we have been seeing today.
James, one of the things that I think really stands out to me, and I wanted to ask you, I wanted to get a legal perspective on this. So you have Brandon Kamek charged with investigating on behalf of the Attorney General's office these claims from Nate Paul. And certainly it's not unusual for the Attorney General's office to carry out investigations. But you have Paul's attorney, Michael Wynn, aiding Mr. Kamek in all of this, you know, sending him list of people to subpoena, sending him documents.
Traveling with him
right.
to deliver these subpoenas.
Is that it? To me, it raises alarm. It seems unusual to me, but you're the legal mind here. Is that normal?
No, it's not normal at all. There's nothing normal about that. But what we just saw in this testimony from Mr. Kamek made it really clear that there was nothing normal about this exchange at all. This was not an official email with the Attorney General's office. The phone numbers they were using were clearly separate lines, and they were mixing different phone numbers. So this is not business as usual with the Texas Attorney General.
Yeah,
I was going to say, even to the point Kamek saying the first time he even saw an official OAG email address was when he was being served a ceased and desist notice to tell him from Paxton's first in command, his top aides, to say, stop with these subpoenas, stop issuing these subpoenas.
Right.
Is it conceivable? I mean, is there any conceivable reason that Ken Paxton is calling from strange numbers? We do know with regard to the email, there was testimony from Jeff Mateer, I believe it was, that they were not using certain email addresses because of a concern that they were maybe getting spied on because they were investigating Google.
And they traveled to China. And so everyone in the AG's office who had took this trip to China, they were using, I'm trying to remember the name of the email, the Proton mail.
Yes.
That they were all using the Proton email. So that not necessarily in and of itself unusual that they would have these email addresses, but I think it certainly raises pause that they were communicating with him here in the States.
Yeah, and also, if you're the Attorney General, why not just pick up your office phone and call Brandon Kamek?
Yeah, it causes suspicion when you're using an email that's not your official email. Like, you're given an official email, why are you doing business under a private email? It just raises some suspicion there. And then we've also heard in this testimony today that the Attorney General himself asked Mr. Kamek to use this Signal app. And we were just looking into that, and it seems that there could be, disappearing messages on this app.
Signal app is an encrypted text messaging app that allows you to, they pride themselves on end-to-end, state-of-the-art encryption to keep your conversation secure, that everything is private and encrypted, and you can send messages and have them delete.
But here's what's yet another thing that's also striking about that. Look, I've read, all three of us have read investigative files, offense reports generated by law enforcement, and they log everything. I mean, they should be logging every action they take, every subpoena that is served, every phone call they make, what the person says. I mean, if for no other reason, to document your case.
Well, and it's really ironic that we're talking about concealment of records or disappearing messages or using outside methods of communication concerning the official that oversees open records in Texas. I mean, this is the official that oversees the release or concealment of open records.
Super gay.
And this is the person we're talking about being offline.
It's like he doesn't even need to be wearing any rainbow stuff.
And if you're one of the 121 Texas representatives who voted to impeach him, you take that knowledge and say, and he had that knowledge, and he knew what the rules were, and he knew what would be able to be requested and not requested, and then he said, let's talk on a secret app, let's talk on a secret email. I'm not sending you anything on my official.
I mean, certainly just for the sake of transparency.
Oh God, this guy's gay too. Holy
Right.
crap! Two gay guys and a black woman.
Would be behaving that way.
Right, because all of us who order open records, and like I said, that could be lawyers, newscasters, parents.
God, these people. Can't stand listening to them. Can't stand listening to these people.
The official that oversees open records.
So as you listen to Mr. Kamick's testimony, I'm just curious, James, what are a few things that stand out to you, other than the ones we've been talking about?
Yeah, well, I can give you some personal perspective as a somewhat new attorney in Mr. Kamick's position. You know, he's only about 5 years into his practice when he gets hired directly by the Attorney General of Texas. And so we heard in some testimony that he was fired up about it. He was excited about it. And that's understandable. He's a 5-year lawyer getting a personal job with the Attorney General himself. But at the same time, we heard him mention that behind the scenes, it was kind of like drinking water out of a fire hose. And so to put myself in his shoes, I think that I would feel the same way taking on such a large job with the most powerful lawyer in Texas. With not a whole lot of experience under his belt yet at that time.
And so I want to ask you about that, though, because we're certainly not here to attack Mr. Kamick's character or say anything about, him personally, but he is a young attorney, and you have someone of great influence. Even in his hiring, he received a phone call from an anonymous number telling him about this job with the AG's office that he should consider applying for. And then he is hired to carry out an investigation that he says he has never carried out anything like. He's never served subpoenas. He's never done any of this before. And you were rather handpicked by Nate Paul's attorney, and that is then said to him to carry out an investigation that Paxton himself said, none of my staff want to do this. So is he a bit naive?
I think more than a bit naive at that point, and we heard Rusty Hardin question him on, how did you feel about, being led by someone under investigation? And Mr. Kamick testified that he wasn't sure if he was under investigation.
Speaking about Nate Paul, that he didn't know at the time. And again, we all kind of, that raised, a moment for the three of us here to say, you knew they raided his property, so you didn't think he was under investigation?
Right. So I think at that level, he maybe should have questioned himself on going forward in his representation.
What am I doing here?
Right.
But again, in fairness, I suppose, I'm working on, at the right hand of the Attorney General. Certainly, the Attorney General knows what's going on.
He made it very clear in his testimony that he was following marching orders from the Attorney General of Texas. And, Rusty Hardin gave him an opportunity to say whether the Attorney General ever said, hey, no, let's not do this. Let's back up. Kamick testified that no, the Attorney General never did that. It was keep marching. Something
else I thought he said that was interesting is he sort of kind of alluded to initially when he took on this job and the job description and the job role as he understood it was that he was going to be able to take this case to court.
Right.
And that he was going to be able to really try this. And certainly that would, I think, bring some excitement for a young attorney to think that you're going to do this on behalf of the state of Texas. But then he later learned, oh no, I'm never going to go to court with this. I'm just doing this.
Gatherer.
Right. I'm just doing this so that I can create this report to give to someone else. And then you're creating this report based off of information from, the person who is the complainant's attorney.
Right.
I mean,
and if he's going to go to trial on this, other lawyers in the AG's office are going to know about that trial. It's like the writing's on the wall.
Nothing secret. But Ken Paxton has maintained all along that he had the authority to hire Kamek, although there's been this back and forth about who actually hired Kamek. It's a tangled web.
Back and forth about it, but certainly under oath. These attorneys have said, and even Kamek himself saying, I was hired by Ken Paxton.
Absolutely.
Ken Paxton hired me, and that raises the question. One, there's an article of impeachment directly tied to this because
I think it's Article 5.
It's Article 5 because that's not how you're supposed to go about.
David Sassa, FBI ASAC Jamie Milligan, and Rob Clark from the U.S. Marshal's Office. There have been a number of significant developments overnight in this investigation and manhunt. At approximately 8 p.m. last evening, a motorist reported seeing a male crouched near the wood line along the south side of Fairview Road, west of Route 100. The motorist turned her vehicle around in an effort to verify what she saw. As she drove back past, the individual was gone. We had a large number of troopers already in the area and utilized them to form a perimeter around that area. A Border Patrol tactical team was also in the immediate vicinity and went directly to the location of the sighting. They observed footprints in some mud which were identical to the prison shoes worn by Cavalcante. A track was initiated, and shortly thereafter, both of his prison shoes were located. Information was received from another resident in that immediate area that a pair of work boots had been stolen from a porch at her residence. The tracking of Cavalcante continued in a northern on Coventryville Road, indicating a short Hispanic male, no shirt, and wearing dark pants, had entered his garage while the homeowner was in it, and that he grabbed a .22 rifle that was leaning in the corner of the garage. The homeowner drew a pistol and fired at Cavalcante as he fled with the rifle. PSP responded and secured that scene. At that time, a green sweatshirt and white t-shirt believed to belong to Cavalcante were discovered near the edge of the driveway. The perimeter was expanded to include that area. Overnight, searches of the area within the perimeter were conducted by tactical teams from multiple agencies. Teams from Pennsylvania State Police, Border Patrol, ATF, FBI, U.S. Marshals, and Chester County have been active through the night. Teams are currently being rotated out and replaced with fresh teams. Aviation assets, canines, mounted patrols, and numerous other assets have been mobilized and are currently operating in this search area. Upwards of 500 law enforcement officers are engaged in securing the perimeter and in conducting the searches. We are mobilizing additional resources as we speak and are planning for an extended operating period if necessary. Cavalcante is considered armed and extremely dangerous. He is now armed with a .22 caliber rifle with a scope and flashlight mounted on it. Throughout the night, we sent several reverse 911 messages to residents within a 3-mile radius of this incident, as well as posted information to social media in an effort to inform the public and to keep them safe. We also notified the affected schools of this incident in the very early morning hours, and the decision was made to close schools in the O&J Roberts School District for today. The current perimeter includes PA 23 to the north, PA 100 to the east, Fairview and Nant Mill roads to the south, and Iron Bridge and County Park roads to the west. We ask residents in and around this vicinity to please secure homes, outbuildings, and vehicles. It is imperative that anyone with information about Cavalcante contact us immediately so we can act.
Crime is riddled, and all we want to do is protect our families, our friends, our communities. I've gone on 2 combat tours with the Marine Corps and fought on the front lines. I've done 11 trips as an independent contractor. She thinks she has the right to take away my freedom to protect my community.
will not comply. Gun owners throughout the state of New Mexico are rising up along with patriot sheriffs and telling their pathetic woke governor where she can shove her ban on the Second Amendment. We're going to see the incredibly delicious irony of how a governor who sought to ban the Second Amendment ended up only making it stronger than ever. Hey, gang, it's me, Dr. Steve, your Patriot Professor, here to help you to think better so you can feel better in these crazy and turbulent times. So if you haven't already done so, you know what to do. Make sure to smack that bell and subscribe button. Also, make sure to share this video with friends and family. We are once again being suppressed by big tech, so I need your help to get the hopeful message of this channel out to as many people as possible. As many of you know, over the weekend, the constitutionally illiterate governor of New Mexico, a woke Democrat by the name of Michelle Grisham, suspended laws that allowed open and concealed carry of firearms in Albuquerque for 30 days after declaring a public health emergency. When confronted with the blatantly unconstitutionality of such a ban, the governor said this.
Yeah. But your point is valid.
You took an oath to the Constitution. Isn't it unconstitutional to say you cannot exercise your carry license?
With one exception, and that is if there's an emergency, and I've declared an emergency for a temporary amount of time, I can invoke additional powers. No constitutional right, in my view, including my oath, is intended to be absolute. There are restrictions on free speech. There are restrictions on my freedoms. In this emergency, this 11-year-old and all these parents who have lost all these children, they deserve my attention to have the debate about whether or not in an emergency we can create a safer environment. Because what about their constitutional rights? I took an oath to uphold those too. And if we ignore this growing problem without being bold, I've said to every other New Mexican, your rights are subrogated to theirs. And they are not, in my view.
No constitutional right is absolute. Your constitutional rights, according to this governor, your constitutional rights are dependent on whether or not she allows you to exercise them. I mean, it's so bizarre because it's as if she has no idea about the Bruin decision that the Supreme Court handed down in June of last year. Because that completely destroys all of this. The Bruin decision, if you don't know, it involved the state of New York. New York officials tried to require gun owners to show, quote, proper cause to get a license to carry a concealed handgun outside the home. Now, keep in mind, the Second Amendment clearly states that every single American citizen has the right to bear arms. We have a constitutional right to carry guns. But the Democrat monopoly in New York is so constitutionally illiterate, so the Supreme Court stepped in and in a 6-3 ruling struck down the laws blatantly unconstitutional. The court agreed that the only person, according to the Second Amendment, the only human being on the planet that should decide what the proper cause is for carrying a concealed weapon is the person carrying it. The person bearing it. That's what shall not be infringed means. And so the Bruin decision has been absolutely freaking out liberals ever since. And that's because it's officially overturning all of these lower court decisions that were upholding restrictive permit requirements for concealed gun carry. But that's all falling apart now, even in the bluest of blue states. So the Bruin decision destroyed any hope this executive order could ever have in being upheld. Plus, on top of that, this Governor Grisham just ironically turned New Mexico into a massive Second Amendment sanctuary. Wait until you see this. But first, gang, we've got something else that's also very, very concerning happening right now. Up until now, the digital dollar or central bank digital currency has been little more than just a headline. But right now, things are developing at an alarmingly rapid pace. It started with a sweeping executive order from the Biden administration, of course, and now central banks are even hiring for their development. And here's the thing, a digital dollar, when all is said and done, means centralized control over your money. It can be used to track your purchases, control what you buy, and even seize or freeze your assets like we saw with the Freedom Convoy. That's why it is so critical for you to protect your money with precious metals like gold and silver. I've partnered with the top-rated precious metals company, Goldco, who've helped patriots all over move $1 billion into the timeless value of gold and silver, and now it's your turn. Right now, they're giving you up to $10,000 in free silver while supply lasts. Plus, all qualified callers this week will receive a free Ronald Reagan silver coin, but that's just this week. So don't wait. Click on that link below right now and do what countless patriots are doing to make sure bumbling Biden never has control of your money. Go to link below and learn how you can get started today. Now, the glorious irony with this nut governor's Second Amendment ban is that she basically turned New Mexico as a whole into a statewide Second Amendment sanctuary. The Albuquerque DA's office is saying openly that they're not going to enforce the governor's executive order. And a number of New Mexico sheriffs are coming out and saying they're not going to enforce it either. Here's the Bernalillo County Sheriff refusing to comply.
Let me be clear. I hold my standards high, and I do not or never will hedge on what is right. And I take my oath seriously. In reference to concealed carry and open carry, the Bernalillo County Sheriff's Office will not enforce this segment of the order. While I understand the urgency, the temporary ban challenges the foundations of our Constitution, but most importantly, it is unconstitutional. My oath was to protect the Constitution, and that is what I will do. The governor made it clear in her press conference. She knew we as law enforcement did not agree with the order, and as a result, this was solely her decision.
Yeah, a decision that she made on her own and that is not going to be able to be enforced. I mean, you already saw it over the weekend when protesters showed up in Old Town Albuquerque, open carrying their firearms, and no police officer there arrested them or confiscated their weapons. Now the vast majority of New Mexico's counties have already declared themselves Second Amendment sanctuaries. They did this actually a couple of years back when their far-left state government started threatening gun ownership. 18 of the state's 33 counties have passed resolutions saying they won't enforce gun control bills being considered in the woke New Mexico legislature. And 29 of the state's 33 sheriffs, 29 to 33, signed a letter saying they won't enforce any legislation being considered that violates the Second Amendment. So that's what's already in place before this nut governor issued the Second Amendment ban. Now, with the state's DA's office saying openly they're not going to enforce her ban, in a delicious twist and irony, Grisham's impulsive woke idiocy only ended up turning the whole of the state of New Mexico into a Second Amendment sanctuary. She tried to ban the Second Amendment, and in doing so, she ended up making the Second Amendment stronger than ever. Hey gang, I know what it's like to feel alone out there in these turbulent times, but I broke free. If you too have been looking for a community with like-minded patriots who are serious about resisting globalism,
I'm concerned about it, but we've navigated through difficult situations before.
to both parties. You gave us a lot of homework during lunch, I'll assure you.
We're just trying to assure you keep your day job and don't ever wander, Your Honor.
Yes, sir. Can I have both parties come up? Mr. Hardin, both
Yes, sir.
parties.
focus on that, you do that.
These are the 5 that are showing intention.
Court's back in session. Mr. Hardin, Mr. Cogdale, we're sustaining the objection on 686 and 691. And then the other ones we'll bring up one by one as we walk through.
Yes, sir.
So 686 and 691 will not be admitted. Bailiff, call the witness. Mr. Hardin, your witness, and now we'll start the clock.
Thank you, Your Honor.
Mr. Hardin, that saved you some time on the clock by resolving some of those issues, so you got your extra 5 minutes. Okay.
Thank you, Your Honor. Something just came up at the well, how do we pronounce your name by your preference? We've said Kamek, we've said Kamak.
Kamak.
Kamak, all right, thank you. Mr. Kamak, I have several documents I want to go over with you. I first want to show you and ask you to look on that hard copy you have there. Do you have a hard copy of 649 with you up there?
Let me take a look. Yes, sir.
All right. And I want you to look at that 649 and without testifying as to the contents yet, tell me if that is a document that was prepared by you.
No, sir.
All right. Who was it prepared by?
This document was prepared by Michael Wynn.
By Michael Wynn?
Yes, sir.
And would you tell us the circumstances real quickly as to how you got that document from Michael Wynn?
This was emailed to me.
Emailed to you? Did you ask for it?
No, sir. This was unprompted.
All right. And then in this particular document, it's still not in evidence. I have a couple more questions for you.
Yes, sir.
When you received that from Michael Wynn.
Mr. Hardin, excuse me. So there was an objection on 649?
Yes, sir. I haven't asked him questions about the content yet for that reason.
Because I'm going to sustain the objection on 649.
But I understood at the bench you wanted us to extend a predicate if we were going to try to overcome it. That's all I'm trying to do. But it's not in, you understand as a lawyer, it's not in evidence. Objection's been made, preliminary sustained. I'm being allowed to ask you a few more questions about it without describing the contents.
Yes, sir.
Okay? Now, when this particular document, and notice here, you forwarded that document to whom?
I sent this document to Mr. Paxton.
All right. And in the case of Mr. Paxton, when you sent it to him, is this an example of how you kept him informed of things that were being done?
Yes, sir. This was one of the ways.
All right. And this particular document, then, did you, that you got from Mr. Wynn, did you use it as a basis to prepare any documents yourself?
No, sir.
All right. Did you do anything with this document?
No, sir.
So, did your testimony, you received this document from Mr. Wynn, you passed it on to the Attorney General. Did you and the Attorney General ever discuss this document?
No, sir.
Did you ever have any personal or over-the-phone contact with the Attorney General about this document?
Yes, sir.
All right, when was that?
It would have been around the time that I received this on this 9/16 date, but I don't recall the exact date that I spoke with him.
Can you discuss that conversation without referring to the contents internally of this document?
Yes, just like in other things that I forwarded to Mr. Paxton, if I had a conversation about it, I would have said, yes, sir, I sent you over something that I got from Michael Wynn or Nate Paul, or Michael Wynn, actually.
Did you represent Mr. Paxton personally, individually?
I'm sorry, could you?
Did you ever consider yourself Mr. Ken Paxton's personal lawyer?
No, sir.
All right. And at that time, had you been retained by, I believe you testified, the Attorney General's office, is that correct? Or who did you think you had been hired by?
The Office of the Attorney General.
Okay, all right. So now, was anything with this document done in your preparation for any of the things you did?
No, I believe I skim-read this document and just sent it on to Mr. Paxton.
Without ever discussing it with him or anything?
Just discussing that I'd sent him over what this document is, but not going into any detail about what was in this document.
And is this a fairly typical process you had through this whole representation during the investigation?
The process of forwarding him emails and maybe discussing things with him?
Yeah.
Yes, sir.
All right. And were you regularly getting emails from Mr. Wynn that you would just pass on to the Attorney General?
I don't know about regularly. I would just have to look at the emails that...
Let me change the word regularly. Then would you frequently pass on to the Attorney General documents or emails you were getting from Mr. Wynn?
I had sent him some things. I just don't recall what those specific documents were. So I don't know if I can say that I frequently did it, but I did send him things and this is one example of it.
All right, and then let me ask it another way, finally, that's all I have on this. Did you attempt throughout your representation or throughout your retention as investigator, try to keep the Attorney General updated on all of your activities?
Yes, sir.
All right. Your Honor, I'll ask the court to reconsider the exclusion of 649. There's a basis here. There's no privilege from anyone. There is on this document, their business record had been filed with this. It's covered by a business record. There is no statement here by anyone other than Michael Wynn. It is not hearsay, though, because he's not making a statement that's being forwarded somebody else's statement. And so for all kinds of reasons, I respectfully request that this be admitted.
May I speak with Mr. Kamek, sorry, Brandon, Kamek, on the predicate question, Your Honor?
Yes, you may.
Mr. Kamek, if you could look at the top of House Manager's Exhibit 649, and I think the fourth line down regarding the subject, it says, does it not, discovery plan dash work product?
Yes, sir.
I'm assuming based upon your designating the document with that description that you considered this to be part of the work product that you were performing in your role as an outside lawyer for the Attorney General's office. Correct?
Yes, sir.
You acted like that was a trick question. It wasn't meant to be.
Okay.
So would you agree with me, Mr. Kamek, that the act of reviewing it and then forwarding it was consistent with your description at the top of being work product? Agreed?
Yes, sir.
So it would be covered by the work product privilege, Mr. President.
So your objection is work product?
Yes, sir.
Your Honor, the work product privilege on this document belongs to this witness and witness alone. And the question would become, if he considers it his work product, he's produced it to us, which waives his work product. And I suspect he would concur again that he's not claiming the work product, and he's the only one in this equation that has the right to, and he's provided it to us voluntarily through this production. So it's waived, even if he did. But
With respect, I don't agree with the last.
I've never heard of a third party waiving somebody else's work product privilege.
I'm simply directing the witness to answer the question, which is, it was sent pursuant to, I'm sorry. Brandon, are you okay on water? You good?
Yes, sir.
We will sustain the objection on hearsay.
Yes, sir.
Mr. Kamak, did Michael Wynn, what is your testimony as to whether or not he regularly or frequently throughout this kept providing you information to assist you in your investigation? Did he?
He did send me information throughout the course of this investigation.
Many times was it unsolicited?
Towards the end, it was.
All right.
Yes, sir.
And would he send you things that were to be, that gave you names that he was trying to get you to issue grand jury subpoenas for?
Objection leading.
That's not leading. That question was, would he do so-and-so? He can answer yes or no. It doesn't tell him which answer to give.
Overruled.
Thank you.
I'm sorry, could you?
Yeah. Would he? Did he send you things did he give you names that he was trying to get you to issue grand jury subpoenas for?
No, sir. He gave me names in an Excel spreadsheet that I think we discussed, but it was never, these are the people that you need to.
But Mr. Kamak, did he also?
Excuse me, may the witness be allowed to finish answering the question?
Certainly. I thought you were through. Were you through?
Were you through, Mr. Kamak?
Pardon me?
Yes, Judge. Yes, sir.
Thank you. Now, what all the kind of information was Mr. Wynn regularly providing you, if he was?
I'm so sorry.
Was he regularly providing you information?
Yes.
And what type of information was he providing you?
There were a couple Excel spreadsheets that he had forwarded to me that had the names and demographic information of individuals as they related to the referral that I got. There was a timeline that I was given early on. There was a memo that was provided to me, like a prosecution memo. There was, and as I sit here right now, I can't think of anything else.
Would you look at 650 up there, please?
Yes, sir.
All right. You got 649 already. We talked about that, correct? The contents are not in evidence. We talked about that, did we not?
Exhibit 649, yes, sir. We talked about it.
And now you've got 650 in front of you?
Yes, sir.
You just mentioned a prosecution memo that he provided you?
Yes, sir.
And what was the purpose of him giving you a prosecution memo?
Objection, conjecture, and speculation.
Sustained. Just rephrase it.
Excuse me, I'm sorry. What was the stated purpose of him giving you a prosecution memo?
That was also an unprompted email to me with this prosecution memo.
Were all of these things he were provided designed to help your investigation of the allegations of Mr. Paul?
The information that he gave me was helpful to my understanding of what the investigation was about and what was to be done.
Yes. And of course, you were conducting an investigation. Your view, you've mentioned before, was that Mr. Paul was your sort of complaining witness as a prosecutor in your mind, correct?
Yes, sir.
Okay. And were these different things that Mr. Wynn was providing you, were they intended to help you in your investigation of the complaint that was filed by Mr. Paul?
They were helpful to the investigation. Yes, sir.
I don't know what, and I'm sorry, I don't want to speak for Mr. Wynn about what the intention was, but they were helpful.
Well, Mr. Wynn was representing Mr. Paul, wasn't he?
Yes, sir.
We can kind of agree, can't we, that he's not going to be providing things to you that are harmful to Mr. Paul? Can't we agree on that?
Yes, sir.
Okay. So would you agree with me as you think about it, that Mr. Wynn was frequently providing you with information that was potentially helpful to Mr. Paul's complaint that you were investigating?
Objection, leading.
Sustained.
Were you getting information regularly from Mr. Wynn? Number one, were you?
Yes, sir.
And was that information designed to help you in investigating Mr. Paul's complaint?
It was helpful.
All right. You know it was helpful then, right?
Yes, sir.
All right. Did Mr. Wynn provide you a prosecution memo for you to adapt into one of your own?
He's provided the prosecution memo to me unprompted, but that was kind of my jump-off point for the investigative report that I was going to ultimately put together and turn back into the Attorney General's office.
Yes, sir. He actually, did he not, provided you a prosecution memo that is 650 that was designed for you to help write your report at the end of the investigation. Is that a fair statement?
Objection, leading.
Sustained.
What was the purpose of this prosecution memo?
I viewed it as giving me information about everything that had happened. More detailed information than just the timeline that I got initially at the first meeting.
Yes, sir. It was all information from the perspective of Mr. Paul, was it not?
Objection, leading.
I'll ask you another way. Was this information, excuse me, was this information offered to you for help, Mr. Paul?
Conjecture and speculation. You can't know what the purpose of it was.
I'll overrule.
I'm sorry, could you repeat it?
You can answer the question. Was this information provided to you to help Mr. Paul or to harm Mr. Paul?
It was helpful. It was helpful from my perspective to be able to wrap my mind around all of the different moving parts within that investigation.
All right, sir. I'm going to refer you to Exhibit 650 in front of you. 650. You have it?
Yes, sir.
It's not in evidence yet, but is this a email sent that you got from Mr. Wynn, or is this an email you created yourself?
This is an email that I created myself, and an email that I sent to Mr. Paxton.
All right, was this email, is this the prosecution memo we've been talking about?
Yes, sir.
And was the prosecution memo prepared by you?
This document was, yes.
All right. And did you use as a basis for this a prosecution memo proposed by Mr. Wynn that he sent you?
Yes, sir.
And then did you forward it on to the Attorney General?
I didn't forward Mr. Wynn's memo. I created my own.
All right.
And then forwarded it on.
So did you forward 650 to the Attorney General?
Yes, sir.
As far back as the date of 9/13, is that correct?
Yes, sir, 9/13.
Now, you're not here today claiming any type of privilege on this document, are you? Did you produce it to us?
Excuse me, those are two different questions.
Down at the bottom, I'd ask you to look and see if you see your name.
Could you repeat
third question?
Yes, did you produce this document to us?
I believe my counsel did.
Yes, your counsel did, I know. In total openness, you provided us about 2,000 documents, didn't you?
Yes, sir.
It was a bunch, right? And 650 is one of those documents you provided us, correct?
Yes, sir.
And you weren't claiming work product privilege at that time or anything, were you?
My lawyers are the ones who produced all of it. I didn't make any claim one way or the other with respect to privilege.
Right, to both sides, correct?
Correct.
All right. So my question to you is this a document you prepared and just forwarded to the Attorney General for his information?
Yes.
Did you ever discuss this document with him?
I did.
When?
I believe it was around the time either just before or just after I had prepared this. I spoke with him about it to let him know that I had sent it.
That you intended what, to prepare a prosecution memo?
Yes, that I had sent this.
To him?
To him.
Did you discuss the contents with him at that time?
I did briefly, just to let him know that I had sent this over here and then it had some ideas about the case.
All right. And so was this designed to let him know that you were working on the case and this is where you were in the middle of September?
Yes, sir.
Okay. Now, again, Your Honor, I move to introduce Exhibit 650.
Objection, hearsay.
Your Honor, there are about 3 different reasons it's not.
Overruled.
All right. Now,
the exhibit is admitted to evidence 650.
I'm sorry, Mr. President, I couldn't hear you.
I'm sorry, I said overruled. 650 has been admitted to evidence.
Now, if we go over to the bait stamp 1986 of Kamek, Stacy. All right. Up at the top, number 6 says establishing a predicate to issue legal process. Do you see that?
Yes, sir.
And it has a list of names there. Where did you get those names?
I got these names from Michael Wynn.
All right. And if we go over to the first page of it, Stacy, can you tell us where you got this heading and the date, what it is? The factual summary, where it says a more detailed chronology is attached to this memorandum. Did you get the information that you used as a basis of that from Mr. Wynn?
Yes, sir, from that original prosecution memo.
All right. So would it be a fair statement that everything you prepared in this document, that the research and writing of it was information provided by Mr. Paul or Mr. Wynn?
So, yes.
All right, I'll let you explain. You said so I want to give you an opportunity if you want to explain that.
Sure. Well, the prosecution memo that I got initially from Mr. Wynn, I'd reached out to him about it after I'd spoken with Mr. Paxton about sending it to him, and as lawyers, I checked with him. I said, I'm going to prepare this and send it over. Would it be okay if I use some of the things that you put in here, statutes, and reviewed some of the case law that was in there? So, he said, no problem, have at it. So I used that as the basis of what was going to ultimately be an investigative report to turn in at the end.
All right, I'm going to show you what is a new exhibit marked 696.
696.
I don't think you have it up there. I want to ask you just to look at this document, first of all, and see if you recognize it. Don't testify about the contents or anything. Okay?
Mr. Hardin, I don't have 696.
No, sir, it's a proposed new exhibit.
Okay.
I don't either.
And my question is simply, do you recognize it?
Yes, sir.
Can you identify what it is without talking about the internal contents?
This is an email from Michael Wynn, dated 9/25/2020, with what appears to be like a Word document attached to it.
Thank you.
Thank you.
And what did you do with that document? If anything.
What I did with it is I read it and I kind of just one ear out the other with it.
All right. Now, is that additional information Mr. Wynn prepared for you?
Yes, sir.
And without going into the contents of the documents, what was the purpose of that particular document?
This document appears to be a list of individuals to approach about an interview.
All right. So let me ask you this. May I have it back?
Sure.
I move to introduce 696.
Objection, hearsay.
Hearsay, we already have a record, a business records affidavit, which addresses whether the reliability of it. It is not a statement. It is a suggestion to this man by a co-conspirator in this case, not a co-conspirator with him, but a co-conspirator with the Attorney General and Mr. Paul, as they keep feeding this information in pursuit of their conspiracy. That's the reason we offer it.
And therein lies the problem. Mr. Hardin suggests as they keep feeding the information. There is zero evidence that Ken Paxton saw this document, participated in this document, created this document before it was sent by Mr. Wynn to Mr. Kamek. And for Mr. Hardin to suggest there's not a statement is belied on the face of the document. Look at the very first page.
The objection is sustained.
All right, may I just for the record add one thing. Mr. Paxton doesn't have to have seen this if there's an actual conspiracy going on. It only needs to be somebody that is a member of that conspiracy. Any overt actor making any statement like that. I just want that in the record, Your Honor. I certainly don't want to quarrel with you.
Yeah, we sustained it to hearsay.
All right, thank you, Judge. Now, let's move forward. You are going to issue grand jury subpoenas, were you not? I said are, but you were. Is that correct?
Yes, sir.
And in preparing those grand jury subpoenas, I think we testified you used the assistance of the AG's office or the district attorney's office to get the forms prepared, correct?
That's correct.
Did anybody in the district attorney's office work with you or anything as to the content or the people they would be sent to or the wording or anything like that?
I believe I received a form from them in an email, like a sample form. That's the only thing that I received back from them as far as assistance goes.
So is what you said, what you received from them, what I'm really asking is, did any lawyer or anyone working on behalf of the content, did anybody try to talk to you about the content or the people to subpoenaed or anything like that?
No, sir.
All right. Was their duty simply aiding you to get the grand jury subpoena before a judge to sign?
Yes, sir. They facilitated.
Did you discuss with anybody in the district attorney's office anything about who you wanted to subpoena or anything like that? Or did you simply provide them the information, they helped you with format and presented it to a judge for you?
Yes, sir. So I just emailed the application for the subpoenas. They did not offer any assistance or make any comments or anything about the contents.
Was there anyone in the Attorney General's office aiding you at all in terms of investigating this complaint of Mr. Paul?
Objection, conjecture, and speculation.
Sustained.
All right. Now, at the end of the time, when you issue these subpoenas, let's go to the dates and times you did it.
Yes, sir.
Did you issue some subpoenas originally by email? You got your billing record up there?
Yes, sir. I'm looking at the...
And your records or your memories show you when you did it? When did you first start serving these subpoenas?
Would have been September 25th, 2020.
Pardon me?
It would have been September 25th, 2020.
All right. And then after you sent, do you remember how many of those you sent out by email?
It was roughly 35 to 40, somewhere in there.
All right. And then after you sent out some by email, then did you reserve some that you were going to serve and serve personally?
I think there were a few that I was going to serve personally for the second referral.
For the second one?
Yes, sir.
So why did you decide to send email for the emails on Mr. Paul's complaint, but decide to serve personally those in the second referral?
Because when can I explain myself?
Sure.
So I have this list that I'm given of individuals that are subject to either the first or second referral. I get that from Michael Wynn. And the grand jury subpoenas were going to go out for email address, like to and from, the email log, to, from, what time, around the time that this search had taken place. And then there were also phone numbers to see if any contacts had been made around that time between cell phone numbers. So I say all that to say this: most of the people who were on this list either had a Gmail account or a Hotmail or a Microsoft account. So rather than piecemeal, let me get a couple subpoenas here, there was no intention of it to be this big shock value of sending out so many subpoenas. It was like, let me get all this information together. I will go through it and then go from there. And with respect to those that I emailed out, that's the way I looked it up. I went and looked that up. Like, okay, how does Microsoft receive a subpoena? Well, you can fax or email it. With respect to the banks that I've served those subpoenas on, I just did it in person.
Well, and then you notice you sent out, did you not, on the emails you did that you were subpoenaing personal cell phones records? Did you send that out by email?
Those were by email,
yeah.
The cell phone records.
So were you sending out subpoenas for personal phone records of law enforcement officers, state and federal?
I'd have to look back, but I believe some of them were.
And were you did you even send out subpoena for the cell phone records of somebody who worked as a deputy for a federal magistrate? A courtroom deputy?
I would have to look, I believe so.
Okay. And then you don't happen to recall on the top of your mind right now who all you did, correct?
I do not, sir.
Okay, that's all right. So then, when you send out these different subpoenas, did you have any knowledge one way or the other that some of the people that you were sending subpoenas to were opposing counsel to Mr. Paul in civil litigation? Did you know that?
No, sir.
All right. If you had known that, would you have done it?
No.
All right. Who did you get the list from as to who subpoenaed?
I got the list from Michael Wynn and Nate Paul.
So is it an accurate statement to say that you issued grand jury subpoenas on behalf of the person that was under a state charges? You issued subpoenas to his agency, the Securities Board.
Objection, assuming facts not in evidence.
Did you realize that? That's really my question. Let me rephrase. Thank you, Judge. Let me put it this way. First person out of the box in that prosecution memo we went over is Mr. Ronnie Saban, right? Did you know that?
Yes, sir.
All right. And you knew him as one of the agents involved in the search, correct?
That's correct.
Were you aware that he was an employee of the Securities Board and was involved in the criminal case where charges were filed and pending at this moment still against the Attorney General?
Objection, assume facts not in evidence.
Did you know that? That's all I'm asking.
Sustained.
Were you aware of what his role was?
Of the gentleman, I think you said Ronnie Saban?
Yes.
No, sir.
All right.
I just only knew him as one of the individuals who had searched Mr. Paul's residence.
Fine. All right. And then different other people. Did you know that Mr. Ray Chester, who was on your list, was opposing counsel in a lawsuit with the Mitty Foundation? Just did you know?
No.
All right. So did Mr. Wynn provide you these names without informing you that part of what they were seeking was information with people that were either in litigation against the Attorney General, namely the criminal charge pending, or in litigation against Mr. Paul,
Okay,
namely the Mitty Foundation? Were you aware of any of that?
Multifarious, assuming facts not in evidence.
It's all in evidence.
No, it's not, and it's multifarious.
We have heard, well, excuse me, let me let the court rule.
Overruled.
Thank you very much. Were you aware of that?
I'm sorry, could you please rephrase that question?
So did Mr. Wynn provide you these names without informing you that part of whatever they were seeking was information with people who were either in litigation against the Attorney General, namely the criminal charge pending, or in litigation against Mr. Paul in the Mitty Foundation litigation? Did he inform you of that?
No, sir.
Okay. Now, then you move on to the subpoenas that you were going to serve personally. And is it your testifying that those subpoenas were based on the second referral that Mr. Paul had filed originally with the DA's office on September the 23rd?
Those were for the second referral.
All
Yes,
right.
sir. Yes, sir.
And that's the referral that you had said you got on the 24th, right?
Yes, sir.
Okay. Now, at the time you sent out these subpoenas the previous week, after you sent them out and the judge signed them and they were ready to be sent out and you sent them out into the world of the internet, did you inform the Attorney General?
I did.
How did you inform him?
I believe I sent him an email.
All right. Did you send him an email at any time letting him know which people you were subpoenaing?
No. I don't think I individually named.
If you need to stay with the microphone, please.
I don't believe I individually named each person, but
All right.
I just don't recall that.
Now, when you went out to serve the subpoenas in person, what dates did you do it and how did you do it?
That would have been on September the 29th of 2020.
September the 29th?
Yes, sir.
All right. And had you made arrangements with Mr. Nguyen for him to go on these services of subpoenas with you?
So he was insistent on going.
What did he, I mean, how long had he been insistent talking to you about wanting to go with you?
Just maybe a day or so. I told them, I was informing them of what I was going to do to serve. I was going to go drop off the subpoenas. And he was insistent on going, and I was like, you don't really need to do that. I didn't really think it was appropriate. But he said, I'm Nate Paul's lawyer, and it's important for me to be there in case they ask you any questions about his case or anything that's going on. And so, I felt a little pressure to say, okay, and he rode along with me.
Share with us why you felt pressure to accede to that.
I think just kind of pressure to perform. I wanted to do a good job, and I frankly trusted Michael.
Right. Did he inform you there was a statute prohibiting an interested party from serving subpoenas?
I was not aware of that.
Okay. And then, so when you made arrangements to go with him, where did you first meet up?
I forgot the hotel I was staying at down here, and he was at a hotel, and I just picked him up and we went.
What day of the week was it? 28th was a Monday, was it not?
I don't know. It was September 29th.
September 29th. I don't think anybody's going to argue if I can say it was a Tuesday.
Okay.
By the way, by this time, Tuesday the 29th, how much contact did you have with the Attorney General about this investigation? How many times? Just first of all, how many times did you talk to him by phone?
Between phone calls and text messages, it had to be somewhere 15 to 20 times range over that 3.5, 4 week period.
Yeah. So that'd be 15 or 20 times that you were in contact with the Attorney General about the case, correct? And leading up to the 29th. And would you agree that you really actively get involved on the 3rd of September?
Oh, I'm sorry, one more time?
Roughly the 3rd.
The 3rd?
Yes. Remember the billing records, the first thing you billed is September 3rd.
Yes, sir, that was a typo. The date that I actually went out there was on 9/4.
All right. So can we say that those 15 to 20 times that you're in personal contact about this case with the Attorney General was 15 to 20 times in the days between the 3rd and the 29th of September?
I think that's accurate.
All right. And how many of those do you think they were personal phone calls?
I'm sorry, what?
How many of those 15 to 20 times were phone calls?
I would have to...
Roughly, just approximately.
Say maybe 7 to 10 times.
All right. How many of them were personal visits?
I didn't have any personal visits during that time.
During that time, you had the first meeting that you described when you were hired. Is that correct?
Yes, sir. I had the 8/26, the 9/4 day, and then throughout the month of September, I didn't meet any more in person.
Okay. And by the middle of it, he is communicating with you by a particular type of encrypted app. Is that right?
Mostly through cell phone text, and then I was asked to download the Signal app, and I don't think we had I don't even think we had a conversation on the Signal app, maybe. I mean, I had that and then my cell phone.
Now, did the Attorney General, did you give the Attorney General advance notice that you were going to be going out on the 29th and serving subpoenas?
Yes, sir.
Had you sent him any preliminary list of who you were serving them on?
No, sir.
Had you told him approximately how many you were going to serve?
No, sir.
How many were you planning to serve?
I believe there were 4 in person. There were the banks who were kind of the ones that were being accused in that second referral of this bank fraud deal.
All right. And so the email subpoenas that you sent out had to do with Nate Paul's referral number 1? Is that correct?
The emails that I sent out?
Yes.
Yes, sir.
Those subpoenas?
Yes, sir.
And then the subpoenas you served in person had to do with referral number 2. Is that what you're saying?
Yes, sir. That's correct.
All right. And when you took, would you just tell us in your own words, recite to us how you served those subpoenas?
We went to 2 banks.
Yeah, let me stop you there just a second. In each of these banks that you went to, did you identify yourself as a special prosecutor for the Attorney General's office?
Yes, sir, I did.
All right. And Mr. Wynn was with you at each one, correct?
Yes, sir.
Did you attempt at each of these banks to do some interviews of the people you served them on?
Just talking to them, yes, sir.
Yeah.
And giving the subpoena.
And did you talk to each of these people during it, in some cases, a little bit about why you were there in terms of the case?
Yes, sir.
All right. And you were there about a case Mr. Paul contended was a mortgage fraud case, correct?
Yes, sir.
And that was a case in which he wanted you to subpoena also or investigate a federal bankruptcy judge, correct?
Yes, sir.
Okay. And then did you conduct an interview of the husband of a court deputy during one of these services of subpoena?
There was I wasn't serving a subpoena. I don't believe it was that was trying to talk to him.
All right, that was an interview without serving a subpoena. Without giving the person's name, unless counsel asked for it, and I think it's in the records, without giving the person's name, who did you go interview? Was it the husband of a deceased deputy?
Yes, I think she was a clerk of the court.
And where had the deceased clerk of the court been a clerk?
She was I forget which court it was. It was the court basically where this first initial referral came out of, the search warrant that came out of that made the basis of the first complaint.
So she was a previous clerk for the federal magistrate?
Yes.
And who were you talking to, her husband?
Her husband.
And did you have some suspicions or so that made you inquire as to how she died or anything?
I think there was I can't think of the right word, but there was like an indication that maybe there was some kind of foul play or something there with this clerk.
Now Mr. Kamak, that had been a suggestion to you by Mr. Wynn, had it not?
And Mr. Paul.
And Mr. Paul.
Yes.
So Mr. Paul tells you a deputy at the court that issued the warrant that I'm complaining about died under suspicious circumstances. That's what Mr. Paul tells you, right?
I don't remember those exact words, but it was something like that.
And maybe not that tone of voice, right?
Yes, sir.
But my point is, he actually led you to somebody that you in good faith interviewed, making you think that this husband might tell you suspicious circumstances of his deceased wife's death, correct?
Objection, leading, and argumentative.
Is that correct?
Sustained.
Thank you. Now, my only point was you issued those 2. You served those 2, were they on the 29th to these 2 financial institutions?
Yes, sir.
And do you remember what the names of the 2 financial institutions were?
I don't recall. I don't recall.
All right. After you issued those subpoenas on the 29th, what happened?
I get back to Houston the following day, and I've received an email from, I think, Microsoft at that point, and then also an email from counsel for one of the banks saying we need some credentials to.
And of course, you had been saying all along to the Attorney General you wanted credentials, right?
Yes, sir.
In order to take care of this particular problem. Is that right?
Excuse me. Third time. Objection leading. Both questions.
Sustained.
Well, when you how many conversations did you say you'd had with the Attorney General trying to get credentials for this kind of work?
I think 4 or 5.
All right. And then once you got those emails, were those emails, if you served them on the 29th, were you receiving those the day after you served them, or would you receive them all the same day that you served them? If you remember.
It would have been after, and you can't quote me on that exact day if it was the 30th, but I do remember receiving emails to the effect of units.
And then what was the next thing that happened in your relationship, in your conduct with this?
I got a cease and desist letter.
From whom?
From a gentleman named Mark Penley.
What did you do?
I responded to his cease and desist and said, okay.
And then did you do anything else besides respond to it? Did you reach out to anyone?
I reached out to Mr. Paxton once I got the cease and desist.
Were you successful in reaching him? How did you reach out?
I believe I called him.
All right. Were you able to talk to him?
I don't remember if it was that, if I spoke with him that day.
Did you also get a visit from federal law enforcement?
I did get, the U.S. Marshals showed up at my office down in Houston.
Yeah. Do you remember what day that was?
Maybe October 1st.
Who was the first? Federal marshals were at your office?
They came by my office.
Who was the first person you contacted?
I called Mr. Paxton, blowing his phone up. Like, why are there U.S. Marshals at my office?
How many times you called him?
Probably 5, 6 times, text messaging, and he answered his phone.
On the 5th time?
One of the times.
All right. And how often were you calling him until you got him?
Well, my secretary comes back and says, there's U.S. Marshals here at the office, and I'm like, what? What's going on? And then I just start blowing his phone up until he answers it.
In your mind, certainly, had you done anything wrong that would merit anybody in law enforcement coming to see you, in your mind?
No, sir.
All right. So the first person you called was the Attorney General?
Yes, sir.
And when you got him, what did he say?
He told me don't talk to him without counsel.
So he told you to get a lawyer before you talked to them?
That's correct.
Okay. Did you talk about the merits or anything of why they were there? Do this. What did you say to him, and what did he say to you?
Yeah, I said there's U.S. Marshals at my office. What is this all about? And he told me, well, don't talk to him without a lawyer. I don't know what it's about either.
Okay.
And then hung up the phone.
He hung up the phone, or you hung up?
I don't remember. We both hung up the phone and went out there and greeted those gentlemen and went to my conference room, and I said, hey, with all due respect, I can't talk to you without having a lawyer present, but can I have a business card? And I got the business card from those 2 gentlemen, took a picture of it, and I sent it to Mr. Paxton. I said, these are the guys who showed up at my office, and that was that.
All right. What's the next thing that happened to you in connection with this?
I had sent my invoice back to Mr. I got a cease and desist letter, and I sent my invoice back